I'd like to mention item number 12 to 24. Very
Well,
Worship, the issue involved in this writ petition are pending before the Honorable Apex Supreme Court. Worship.
we'll see when the matter is.
Lord.
Merely because it is pending hardly matters.
I have the present status of the Supreme Court.
Huh?
I have the present status of the Supreme Court matter. So last
As the Supreme Court state, the High Court should not adjudicate. Has the Supreme Court said that? If it is not said, then I am also bound by the Supreme Court judgment wherein it says that unless there is a direction for the matter not to be taken up by the High Courts, the matter has to be taken. Next.
kindly, Lordship, adjourn for the day, Lordship. I will.
2013 matter.
This part of my senior is also not in station, Lordship.
Can't help it.
Lordship.
Next. May it please, Your Lordship, in item number 1, I have filed one additional affidavit, Lordship.
In item number 9, I have filed one affidavit, my lord. I may be allowed to call that.
Alright.
Lord, in item number 7, we have filed an affidavit in opposition on behalf of respondent number 5. This is not on record and it may be kindly called.
My lord, I'm appearing on behalf of A. Saranya. Today's item number 25 is to be adjourned for the day with the permission of the other side. And fixed on a later date.
What do you want?
Adjournment, Your Lordship. It has been already notified to the other side. He is out of station.
We are paying for the KAC. You've taken the consent.
Yes, sir.
Interim order.
Yes.
You have no objection? Okay. We listed in due course then. The counsels for both the parties submits that the matter is to be adjourned. Accordingly, list the matter in usual course. Interim order there. Interim order passed earlier shall continue till the disposal of the writ petition.
Your Lordship, if the court pleases, it can be listed after vacation.
Absolutely no. It can't be at your request. You either do the matter or don't do the matter. This should not come up. Why? This is an out of turn matter. There are all 2013-14 matters.
Obliged, Your Lordship.
There's an interim order. There's an interim order in this matter. Oh, file interim order. Neither is 9. File to devote.
First, I pray for listing to matter for withdrawal. To matter listing for withdrawal.
Motion.
Withdrawal, Your Lordship. So, tomorrow.
Top of the list, item 1.
Yes, Mr. Chaudhary.
Lord, today I am entering appearance on behalf of respondent number 7.
Who's 7? Oh, okay. No, 7 is okay. I'm not on that.
I have read the 2 orders passed by your lordships, although I could not get enough time. Lord, I'm come prepared with some little answer. Not I mean whole hog, but my lord.
No, respond number 7 means earlier Mr. Mahmood was appearing.
Yes.
No, I get it. Now, the main issue out here involved is
Yes.
how do you take care of a situation where they are, although Assam Land and Revenue regulations apply, how do they bring in another appellate authority? Wouldn't that be in conflict with 147?
Yes. My lord, the answer lies in, if your lordship will kindly have the 6th schedule.
Huh?
6th schedule to the Constitution.
Yes.
Prima facie, my lord, I'm not saying conclusively.
The Constitution could do.
Constitution only.
Yes.
First come to para 3, my lord.
Interim 9, huh? Okay, there is no interim. Why did you say that there is an interim? Why did you say that there is an interim?
Lordship, actually, the facts of the case, was summarized wrong by me while going through the file this morning.
You should not mention it like any year. What's your name?
And Google.
And Google. Hey, kola kitabot lekho. Blacklisted. Yes, next.
Lordship.
To be listed in its usual course. Post.
Sorry to be going.
Apologies, Lordship, but
Yes, Mr. Chaudhary.
Yes.
I'm sorry, dear Lordship.
It's okay now.
Please come to
Oh,
para
thank you.
3, Miller. Power of district council and regional council to make laws. This is generally the power. The regional council for an autonomous region in respect of all areas within such region, and the district council for an autonomous district in respect of all areas within the district, except those which are under the authority of the regional council, if any, within the district shall have the power to make laws with respect to, highly similar. Please come to the next page. A, allotment, occupation or use or the setting apart of land other than any land which is reserved for forest for the purpose of agriculture or grazing, for residential or other non-agricultural purposes, or for any other purpose likely to promote interest of the inhabitants of any village or town. This is generally, Miller. Now, if your lordship will, amongst others, this is the power. Now, if your lordship kindly comes to 3B, now specifically after Boroland Territorial Council was, Milord, created, this is the provision which was inserted. Without prejudice to the provisions of paragraph 3, the Boroland Territorial Council.
You are referring to?
Para 3 capital B, Milord.
The
I think it will be in the, it was subsequently it was inserted. It will be there. I think below, I think the note portion, it will be there. 3A is additional power for NC Hill Autonomous Council and Karbi Anglong, and 3B is regarding Bodoland.
yes, 3B.
Yes.
Ah.
Without prejudice to the provisions of paragraph 3, Bodoland Territorial Council within its area shall have power to make laws with respect to, please come to my lord, Roman 15. Land and revenue. These are all transferred subjects.
Hmm.
Now, if your lordship should kindly come to paragraph 11 of the 6 schedules.
আবাজ এটা পড়ি আছে কি হয় আবাজ? Yes.
Para 11. Publication of laws, rules and regulation made under this schedule. All laws, rules and regulation made under this schedule by district council or a regional council shall be published forthwith in the official gazette of the state and shall on such publication have the force of law. Now, my lord will kindly come to Article 13 for a moment. Article 13,
3A.
sub-article 3. In this article, unless context otherwise required, law includes any ordinance, order, bylaw, rule, regulation, notification, custom, or uses having in the territory of India the force of law. Having regard to this legal background, if your lordship kindly comes to page 47 of the, it's a part of the affidavit filed by the PTC Miller, where that notification dated 30th December 2016 is there.
Yes.
Whereas as per clause 5.7 of the MOS 2003 and the Government of Assam memorandum dated so and so, the office of the Deputy Commissioner and Superintendent of Police are kept outside the superintendence and control of BTC, and land and revenue is transferred as a transferred subject of BTC. So, my lord, so far as control over deputy commissioner and superintendent of police is concerned, it will vest with the state government, not with the BTC. And land and revenue as a subject stands transferred to BTC. Therefore, the council head of department directorate formed by BTC with regard to land and revenue department write notification dated so and so and notification dated 25/1/13 and dated 9/4/13 and 9/10/13 respectively shall be competent to deal with all land and revenue matters of 4 districts and powers of deputy commissioner as provided under Assam Land and Revenue Regulation shall be vested on the Director of Land Records, Survey and Inspector General of Registration of BTC, and appellate authority in this context shall be Departmental Secretary of BTC. Only thing is, my lord, I think this must have been gazetted, my lord. That lordships will have to verify. Privacy, my lord.
But whatever may be,
Yes.
once you have adopted the Assam Land and Revenue Regulations, which I could say in places like in Nagaland, they have adopted the Assam Land and Regulations. When they adopt it by way of an executive instruction or anything, then they have to specify which are the sections which are not adopted.
That's why I said, my lord, go by the normal proposition. An executive order, by an executive order, we cannot override a statutory provision. But having regard to, my lord, the peculiar, governance system introduced by 6th schedule, what will be the effect? That is an aspect we'll have to examine.
Now, the problem arises with this. You have out here in this case, if you see the facts, an order is passed by the assistant settlement officer. Normally, an appeal lies to the settlement officer.
Yes.
But here, the BTC has done.
The Secretary BTC, Revenue.
Now, even if we take this also, how is it possible? Unless you are changing there also.
So the question which your lordships frame in the order,
No, that is there.
yes, yes,
And therefore, I'm asking you,
yes, yes.
that is one aspect. But how do you take care of the BTC secretary exercising a power over the ASO? Because what you have done, let us assume that this is then been notified.
No, my lord, it's a matter which needs to be gone into. There can be no manner of doubt. But will give me little time. Let me apply my. Yesterday evening, these people came, my lord, privacy. Having gone through a lordship's order, I thought this would suffice. Anyway, it's a matter which needs to be gone into. There's no doubt about it.
Now, Mr. Advocate General, we were
Yes,
supposed
Lord,
to
I-
make
I-
this submission. How is
My
it?
line is very clear. By Lordship's last order, maybe the second last order, Lordship picked up this issue. And we have also submitted a written instruction where we have annexed a 2016 notification. That notification, prima facie, Lordship, it may not be sustainable, but there is no challenge to it.
No,
If there is no challenge to it,
There's no requirement of a challenge to it. If
no,
the
I'm
provision is not
on
there-
a very peculiar stand, Lordship. My stand is very clear. They have said that the impugned order is bad on 2 grounds. One is that the principle of natural justice was not followed. That is one ground. The other one is that the particular concerned authority does not have the competence. On that ground, Lordship may decide the matter. In appropriate cases, when the 2016 notification is put to challenge, will appropriately address the honorable court. That is my first submission. And it has also come to our notice that there is a flaw. We can also argue on 6th schedule and all these provisions. In appropriate case, we'll definitely agree, but we have already started a rectification process. Already,
It's okay. Now the question.
on the facts,
No,
Lordship may
why
decide this
I'm
matter without
saying,
going into 2016's validity.
it's not the question of validity. The question is when a question of jurisdiction is being said, you say that there is a notification, an appeal lies from here. Now the question therefore arises, can you have 3 rounds of appeals? Why
fully
your,
agree.
because you have already submitted by way of an instruction before this court that look here, an appeal lies to the Director of Land Records.
Absolutely.
Second, an appeal lies to the BTC. And against that, an appeal lies to the Board of Revenue.
Yes.
Now,
That is 147.
understood. But are you not amending 147?
That is the process we have initiated.
Huh?
That is the process we have initiated because we have to have in our EC meeting, we have already taken note of this Lordship's observation. One stage has gone up and in 6 months time, we will rectify all the lacunas. Whether 147 should be amended in the context of BTC, that's a significant. Karbi Anglong has already done it. We have taken a cue from that also.
What has the Karbi Anglong done?
Karbi Anglong has appropriately, this is the verbal instructions I have received, that they have appropriately amended the provisions of 147 in respect of Karbi Anglong. I do not know, I have to look into it. Karbi Anglong has said,
Let me have a look.
it is already there. So we'll do it also. In fact, we are in the process, because Lordship has rightly indicated that flaw, when it will be challenged, we will have a tough time. We will be in a sticky weekend. So we have trying to rectify. We have also looked into the 2016 file in a very casual manner. It was done. That
No,
notification.
no. Now, where will the appeal will lie? Now, let us set aside.
Will-
No, now the problem arises. Why? I understand everything. Now, if I hold it on the question of natural justice,
Then we'll appropriately amend it. I
No,
cannot
no,
say what will be the
no,
final
Mr.
outcome in
no,
the assembly
Mr.
of the BTC
Mr.
as well
Advocate
as the
General.
state assembly.
Mr. Advocate General, kindly understand. Let us hold it that yes, apparently there was no
As
natural
of
justice.
apparently, Lordship's opinion is absolutely correct.
No, no,
I have no quarrel on that.
I understand that number. Question arises is the moment I hold it on the second aspect, that is natural justice violation. Where will they go? Where will the appeal be decided? There the problem arises, where will they go?
Now,
As of now, then don't you think that this court has to direct against the BTC, the secretary, on the basis of this notification? But is it permissible?
but whether it is permissible in the 226 proceedings when there is no challenge to it.
Not necessary to challenge when I have already raised that issue.
Lordship
It's a
may be
different
pleased
thing.
to raise, but when there is a challenge and there should be a pleading, in that case, Lordship will give us if it is
That
not
is
a part
what
of
I have
pleadings.
raised. I have raised not once, twice, thrice. My
Absolutely,
orders
but
are very clear on
umpteen
that.
number, the law is well settled.
And that is on the last time, Mr. Rava said that on this aspect, the Advocate General will
Yes, that's
submit.
why I'm
And,
appearing,
and
Lordship.
therefore I have accommodated this matter to be taken up
No,
on this, on
No,
the
no,
basis of that.
my humble submission is very clear, Lordship. The writ petitioner has not put to challenge the 2016 notification. Lordship has already brought it to their notice also by that order. Have they challenged it now?
Not
Till now,
necessary, because the
that is
question
necessary
arises.
as far as my
No.
understanding of the law.
Understood. That may
That
be
is
a
one
very,
thing.
very good ground for the BTC to challenge my order before the division bench. It's okay, you challenge it. But the question is, when I set aside this order, where will the petitioner go or the response number 7 go? How do you take care of that situation?
In that situation, still, the subject matter of the present writ proceeding is not the 2016 notification. If they, without a challenge, Lordship is pleased to interfere. I have no opinion to.
No, how do I interfere? Means interfere and go where? There the problem arises. Go where? Where will the parties go?
Lordship
The
may
moment
remand
I
that
set
back to the
aside,
same authority.
that
natural
means the
justice.
moment I send it there, means I am giving, in spite of raising those issues in my order, wouldn't that amount to an order of res judicata?
Then Lordship may direct them to amend their writ petition.
Not necessary. That I will
Then I
take
leave
care.
it to you. I cannot dictate Lordship's
Yeah.
but I have to make my submission. My submission is loud and clear. As there is no challenge, I will rely upon 2-3 judgments of the Supreme Court also. As there is no challenge to a particular cause of action, then the Honorable Court would not like to enter into that arena. That is my first submission. Regarding the other part, if the 2016, this Honorable Court is pleased to take up and expressing an opinion finally, then Lordship may give us sufficient time. Otherwise, our right of natural justice will be violated. By verbally making any submission will not be suffice. It should be done in proper way, then appropriate affidavit will also have to come.
No, that is why I've raised those issues and given you time for filing affidavit.
We
I
have
raised
received,
that issue,
we have
that
received all the
asking to file
instructions.
an affidavit.
Then
How
Lordship
is
will
do
give
you
us
do
2
it?
weeks time. We'll raise all these issues to an affidavit. But on the other hand, on the hindsight, Lordship, we are taking corrective measures.
Sir, you do it. You see that why the
In
matter.
that matter, Lordship,
the
may keep the
matter had to be
pending for few months, 2-3 months. In the meantime, we will do it. Lordship may keep the matter pending. We'll see, we'll try to expedite the matter also. There has to be 2-3 assembly sessions. That is the only reason. One before the BTC, one, the EC committee has already approved it. The verbal instructions I have received. Next, there will be a assembly sometime in
No, why I tell
immediately
you-
after Puja, then the winter session of the state assembly will also be required.
Understood. Now, why I tell you is this. In Nagaland, the Assam Land and Revenue Regulation has been adopted.
Lordship.
In Arunachal, now they have it, but earlier it was not there. Earlier also they adopted it. Now, as Nagaland comes under the 6th schedule,
Lordship.
while adopting it, they say we are adopting it by way of an act. By way of an act, it is being adopted. Here also by way of an act, it has to be, and saying that instead of this provisions shall not apply in this, and this should be substituted by this. Unless you do that, if you see the Nagaland code, volume 1, you get the idea how it is done. It is in this manner you have to also adopt it.
Lordship.
If you don't do it, then the problem arises all the time.
Lordship. I fully agree.
Now, this matter was not so urgent for me to take it up. It was because of the behest of the respondent number 7. They have been trying their best to get this matter done. And that is why this matter was taken out of.
We are
court. There
taking
is
it very
already a
seriously,
stay
not
order.
because of the sole personal issue. On a bigger issue, we are taking this, addressing this.
The bigger issue is there where, because this issue, otherwise it amounts to amendment. Yes, you can have.
Yes.
You can very well amend it and say that we are adopting, however, we are inserting this BTC secretary. Very well, that has been done, which is there. In Nagaland, they have done that.
We have 2 options open. Either properly amend it.
No, you
To
don't
give
need
the
to
authority in
amend the, you have to pass an.
Or maybe we can
order.
also have a revenue board in BTC. That option is also open.
You can do whatever maybe,
Yes.
or say that these
We are
provisions shall
deliberating
not,
on those, Lord.
because you have already adopted the Assam Land and Revenue
Absolutely,
Regulation.
Lordship.
So while adopting it, you need to come up with this
Yes.
notified
Absolutely.
and which is the official gazette.
In fact, only because of this notification, this exercise was being done. We have no difficulty in allowing the matter to be taken up by the board also. That is also one of our opinion. There is no difficulty, only because of the 2016.
And apart from that, what has happened is you, on one hand, why you are doing it, on one hand, you are saying, because the superintendent of police and the DC is outside,
Yes,
but
this is one part.
no, therefore, you are saying instead of the DC, it will be the Director of Land Records. And against the order of the Director of Land Records, an appeal lies to the BTC Secretary. That is one. Now here is a case, you have not taken into consideration that the ASO or the settlement officer is your officer. So an appeal lies from the ASO to the settlement officer who is your officer.
Lord.
This is a case where the ASO passes an order. And an appeal lies to the settlement officer because you have a settlement officer which is the BTC person.
Right.
And therefore, here what he did, he filed it before the BTC secretary. Now, if we even go by this notification also, if it was against a DC's order, you go to the BTC secretary or the direct, it becomes a Director of Land Records order, you go to the BTC secretary, it's okay, as per this notification. But when the SO or the ASO is under the BTC, how do you apply this notification? Think about this, whether that issue will arise
Yes.
in this, taking into account that it is an SO. Because SO is under you.
Settlement of.
So this is another way of disposing of the matter, saying that BTC secretary may not exercise, SO can done, because SO is yours, ASO is yours, all are yours. Only the DC is not yours. Because how many ASO, SO is there, the appeal as per 147 also.
Lordship may dispose of in that line also, I am agreeing.
No,
It
that
is
is
so that-
one aspect.
Yes.
Think about it. We
Otherwise,
have
but
no time.
If
But-
there is a lacuna, we have to, because we have gone through the file, all my colleagues have gone through. Only a casual, very mechanical manner, that order was passed without any discussion, without any deliberation in 2016.
No, this will be required at a later stage.
In
Some
one,
bigger
at one
case will-
stage, we will be cornered.
Huh?
At one
Yes.
stage, we will be cornered. So we are when it has come to our notice after Lordship's order, it has opened our eyes and we are applying our mind now.
No. We will adjourn it let us have it in the month of December. On
Yes,
2nd of December, let us have it, 3rd of December. In the meantime, you carry out
Lord.
whatever exercise is required, you have
Lord.
it. The
Highly
interim
obliged.
order will continue. You are enjoying an interim order.
Yes,
She is not in urgency. It is the respondent number 7 who is in urgency. So now
Lord,
they have,
highly obliged.
now they have taken a back foot.
So
Mr.
we want to clear up this.
Another issue I'm just telling you, this may not be another issue I'm raising, another issue in another matter. You being the Advocate General, I'm telling you.
Whatever I have submitted, Lordship will observe some of the lines.
Yes,
So that
I'm
it
doing
will
it. I
make
will,
clear for the authorities also to act.
no, that I will
Yeah.
do it. Another issue I'm just telling you because you are the Advocate General. You are having the Assam Mala scheme. The Assam Mala scheme, it's a very good scheme. You are giving a better thing which is given under 101 of the 2013 Act. You are giving it that the state can always go for a higher compensation. You can give it. But how are you taking over the land unless you are bringing those two acts? Just for example, the Land Acquisition Act or the Right to Fair Compensation Act says that pursuant to the passing of the award and taking over the possession, or the possession being taken earlier, and the passing of the award, the land vests upon the state. If you are not putting those two acts, that day I was putting it to Mr. Arbor Pujari this, because tomorrow you will be honored in such a manner because there is no vesting of right unless you bring. Because on the basis of a statute, you can vest. And otherwise there has to be a sale deed. Now,
Change of title.
yes, there has to be a change of title somewhere. Because of operation of law, that is section 16 in the earlier act, or even by, if you go by the Assam Land and Acquisition and Requisition Act, section 6 or section 9, it gives you a power. It says that the moment you pass the award and take over the possession, the land vests operational. National Highway Act, it also says 3D, that once the notification is passed, the land vests upon the state. No, unless you draw those or link those, your categorical stand which was made on that day is not linked with this. We are giving a better scheme. Now, if you are giving a better scheme, how do you transfer? There has to be an operation of law somewhere.
So we'll look into that also.
I told him because tomorrow, now you are doing it. A few matters are coming. One fine day, it will be such big, it will have a far-reaching that none of the land has vested. How do you take care of it?
In spite of paying the compensation.
Huh? You are on the other hand, you are paying higher compensation on the basis of an agreement. Agreement for sale does not confer any title. Heard Ms. R. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. D. Sakia, the learned advocate general, appears on behalf of the BTC. The learned advocate general submits that the BTC authorities have already taken up the issue pertaining to the notification dated 30/12/2016. And also taking up certain remedial actions.
And deliberation is also.
And also deliberations are presently going on as regards what remedial actions are required to be taken to make the said notification in consonance with the sixth schedule of the Constitution. He therefore submits that as
Vis-a-vis the Assam Land Revenue Regulation.
sixth schedule of the Constitution vis-a-vis the Assam Land and Revenue Regulation 1886. He therefore submits that some time may be granted as the authorities are looking into the said aspect. This court taking into account that Mr. K. Chaudhary, the learned counsel appearing on senior counsel appearing on behalf of the respondent number 7, submits that he also requires some more time as he had been newly engaged in the matter. So, taking into account the above, lists this matter on 3rd of December 2024, on which date the respondents, the BTC authorities shall give an update as to what remedial actions have been taken in respect to the notification dated 30/12/2016. Full. The interim order so passed earlier shall continue till the disposal of the.
Lordship,
Highly obliged.
Making it as partner.
Huh?
It will be.
Yes,
listed as
I'll be
part-
more than happy, Lord.
No, no part of business. Part of the people will look into.
Obliged.
No, because tomorrow a big issue will arise.
Yes. We are already on job, Lord.
You see the Nagaland Code Volume 1.
Yes, I'll.
This is how they are adopting. Even the owner shell code also, they were adopting many. Like the Assam AIO is also, Assam Land and Revenue Regulation has been done. They have also done, for the example, the Land Acquisition Act. Because in owner shell you can't apply unless the governor says. So there also, it is how it is being done is, they categorically say that this particular provision, the collector shall be named the DC. This is how it is being done. Have a look at those acts. This may aid you.
Obliged.
Has done it, Karbiang. Deeply obliged.
For admission, item 6.
Oh, yes. What is happening? Assam Pharmacy Council.
Yes, this is a matter, the council is a statutory body under the Pharmacy Act. And they are espousing the cause of the association, council for non-implementation of certain provisions of the Pharmacy Act. More especially section 26A for appointment of inspectors under the Pharmacy Act, and section 42 dispensing of medicines by registered pharmacists in the pharmacies. Those two specific provisions. The proposal that was made by the Pharmacy Council was rejected by the Health Department, Government of Assam in the Health Department, on some of the grounds which are that there are drug inspectors who have been appointed under the Drugs and Cosmetics Act, and they can perform the act, the functions of the inspectors who are sought to be appointed under the Pharmacy Act. That is one objection. Second, then there'll be an overlapping of domain, because there are already drug inspectors there. People will get confused, the pharmacists will get confused. Thirdly, that there'll be liability on the government if they are allowed to, Pharmacy Council is allowed to appoint inspectors. Now, we have stated in a writ petition, now the inspectors who are appointed under the Drugs and Cosmetics Act, they cannot perform the duties of inspectors who are to be appointed under the pharmacy. These two are acts under totally different domains. Their objects, their in the field which they are sought to be operated, clearly enumerated in the different acts, the Drugs and Cosmetics Act and the Pharmacy Act. I'm just giving, I'll elaborate it on, and then secondly, the apprehension regarding liability, which is raised by the government, that will not be, because the inspectors who will be appointed under the Pharmacy Act, he'll be an officer, employee of the Pharmacy Council, and his remuneration will be borne by the council, not by the government. It's there in the act. Then,
Let's see the Pharmacy Act.
yes.
Pharmacy Act of Drugs and Cosmetics. Right, that's all.
Asan? Dapat. Kan biasa nggak products. Agora uliye sila to. Ekon.
So they have not notified the rules. pertaining to qualification,
Qualification.
powers and duties of the inspector. They have not.
Notified, because rules etc. regarding qualification that
Now
will be laid
inspection as per the Pharmacy Act is to be done by whom?
down, by the inspectors under section 26A.
A state council may, with the previous sanction of the state government, appoint inspectors having the prescribed qualification as in 3, 4, and 5.
Inspector may. That's okay, inspector,
Tell me, how can an inspector become a public servant if he is an appointee of the state council?
public servant, yes. That
And
is,
it is not born out of the coffers of the state government?
public
State
no-
council is what? Constitution of the
it's a
state council,
statutory body
6
under the,
members elected
Pharmacy
from
Act.
amongst by registered pharmacists of the state, 5 members of which so and so, 1 member so and so. Now, do you have a state council?
Yes,
What is
The-
that? The Assam Pharmacy Council.
pharmacy council, yes. State council.
So
is-
you have that state council.
Yes,
So you have the power to appoint,
yes.
but in consultation with the
With
state,
the previous sanction
With
of
the
the
state government.
state government, yes. We require the sanction of the state government.
state
for
government you are
appointment.
doing, and prescribed qualification for the purpose of chapter 3, 4, and 5. 3 is 3,
46 FF.
4,
46
4
FF
is
is
registration of pharmacies, and 5 is miscellaneous penalty and all these things. So they can do the pharmacist.
yes,
Now, they have not notified the rules,
regarding qualifications of,
powers and duties of the inspector.
yes. The,
So that has to be in consonance with chapter 3, 4, 5 again.
yes,
So you're therefore the question, the issue which you are raising is there's a requirement as per the act to have inspectors.
yes,
Inspectors are to be appointed by the state council in consultation with the government. Number 3, what is the purpose? Purpose is chapter 3, 4, and 5.
yes, for carrying out the, yes, objects. of
And
yes.
the qualifications are to be done under 46 FF,
Perfect.
which the state government have
State
not.
government has to lay down, yes.
Now, therefore, the question is, if the state government does not have the rules of the qualification of the inspectors, can the power to make inspection to the pharmacies be conferred upon any other authority?
I'm not sure, I didn't get it properly. In absence of rules,
In
Whether-
absence of rules,
yes,
where there is no mention as to what will be the power, qualification, and duties of the inspectors, which the state government has not done, can pharmacists be inspected by any other person other than any other persons?
from, for the purposes of, under the, these inspectors are to be appointed, only the act provides that inspectors have to be
So
appointed.
therefore, madam, the question which I am putting to the state,
Yes,
because state says that this inspection we are carrying out to the drug inspectors.
that is not what they say, that,
Madam, kindly understand. The state say that we are doing it through the drug inspectors.
will do it, yes.
They are doing it through the drug inspector. But can the drug inspectors do without there being the rules framed under 46M?
No, no,
There is a regulation, my lord. Pharmacy practice regulation, my lord. There, my lord, the powers and duties have been defined.
No, how can it go beyond the act?
No, in act also, because my lord, in section 26A, my lord.
Hmm.
26A of the Pharmacy Act, my lord, the powers and duties of an inspector is defined, my lord.
Yes.
And in the regulation also.
An inspector may, no, inspector appointed under this.
And the
An
regula-
inspector appointed by the state council
Yes,
is
ma'am.
there.
If your lordship come to the regulation, my lord, there the inspector appointed under the Pharmacy Act as well as the inspector appointed under the Drugs and Cosmetics Act, my lord.
Where?
PPR 2015 5, regulation 5.
You are referring to which one?
Regulation 5.
Regulation 5, my lord.
He is referring to regulation 5.
Regulation 5, my lord.
Page 32 of that act.
Because the drug inspector here are appointed under the Drugs and Cosmetics Act, my lord.
The owner registered pharmacist shall allow and cooperate with the inspectors appointed under the drugs and so by the state to inspect the area where drugs and compounded area. So, how does it matter? How does this have any relevance? Because the owner has to cooperate. This is a regulation which is the mandate upon a pharmacist that you are to do so. But that does not give the power of a drug inspector to exercise the power of the state pharmacist.
My lord, B, my lord. Any inspector may,
B.
yes, my lord.
Now, any inspector means any of the two inspectors
Yes,
may.
Yes, sir.
Now, but if the power is not given, you are not appointing a person in per this act.
Yes, my lord.
This inspector can only look into the drug inspector's power cannot be exercised by the pharmacy, the inspector for pharmacy. He cannot
My lord, the inspector appointed under the Drugs and
inspect
Cosmetics-
where drugs are compounded. Are you saying because of that, a pharmacist, a pharmacy inspector can also inspect any premises where drugs are compounded? He has no business out there.
My lord, the section 5 says pharmacy inspectors to inspect pharmacies. So here, my lord, the owner registered pharmacist shall allow and cooperate with the inspectors appointed under the Drugs and Cosmetics Act and section 26 of the Pharmacy Act 1948 to inspect premises where drugs are compounded or dispensed. Any inspector means, my lord, both
Okay,
inspector.
then
Both inspector, my lord, the
exercise this inspect any inspector may
Yeah.
inspect so and so, inquire so and so. This is in correlation with 5A. You cannot read 5B
Yes, my lord.
separately.
5A,
So if the act does not say so,
5A empowers both the inspector, my lord.
it
Inspector,
cannot be. When the act only empowers them to inspect, it is only the pharmacy inspectors.
my lord, Drugs and Cosmetics, 5A says, my lord, both the inspector have
We
the power.
hold that no person can inspect unless there is no appointment there.
So that
my lord,
interpretation will
I
render
will say-
section 26A rotors.
No,
Yes.
it won't.
Yes.
They would be bound then. Madam, kindly understand. The moment I say that the pharmacist cannot be, as insofar as what is there under chapter 3, 4, and 5, the drug inspector cannot, it is only the pharmacy inspector appointed under him can do it. You'll be bound to appoint them.
No, my
Yes.
lord.
They'll
And-
have to
and-
fill.
I-
Yeah.
Conferred with more powers.
Huh?
The inspectors under the Pharmacies Act will be conferred with more powers if that interpretation is given. Any inspector, that is what he is reading 5B
Yes.
isolation, which he
Hey,
cannot.
he
do.
cannot. No,
Yes.
therefore I am saying that unless there is an appointment of inspectors under section 26A by the State Pharmacy Council, in consultation with the government, there can be no inspection of the pharmacist, of a pharmacist insofar which comes within the ambit of 3, 4, and 5.
Yes,
If that is then they will be bound.
yes.
That is your answer. That is why I put that question to you. That is an answer, okay. Heard
lord-
Miss D.
my lord,
Buragoy Dalani.
section-
No. Others is for appeal for you.
No, 5A says both
Not
the inspectors have
necessary.
the power, my lord.
Not
Five-
necessary.
5A says both
We'll
the
consider it in the appeal. File appeals.
5A says, my lord, both the inspector have the power, my lord, that
Heard
power.
Mr. D. and Miss D. Borguhai, the learned counsel appearing on behalf of the petitioner. Mr. D.P. Bora, the learned standing counsel, appears on behalf of the Health and Family Welfare Department. The petitioner number 1 is the State Pharmacy Council, constituted in terms with Section
Thank you.
19 of the Pharmacy Act 1948, hereinafter referred to as the Act of 1948. First, the grievance of the petitioners herein is that the respondent state government is not permitting the appointment of the inspectors under Section 26A of the Act of 1948. The petitioners also assailed the inaction on the part of the state government in not framing the rules in terms with Section 46 FF of the Act of 1948. The petitioners have also assailed the order dated 28/7/2021 whereby the Principal Secretary to the Government of Assam Health and Family Welfare Department have rejected the proposal of the petitioner to appoint inspectors under Section 26A of the Pharmacy Act 1948. In order to deal with the grievance of the petitioner, this court finds it relevant to take note of the Act of 1948. The said Act of 1948 was enacted to make better provisions for the regulation of the profession and practice of pharmacy, and for that purpose to constitute pharmacy councils. Chapter 2 of the Act of 1948 deals with the Pharmacy Council of India. Chapter 3 deals with the State Pharmacy Council. Section 19 of the Act of 1948 stipulates how the State Pharmacy Council would be constituted and its composition. It is an admitted fact that the petitioner number 1 is the State Pharmacy Council. In the same chapter, Roman 3, there is a provision being section 26A, which relates to inspection. The said section is reproduced hereunder. From a perusal of the above quoted section, it would be seen that inspectors are to be appointed by the State Council with the previous sanction of the state government. The said inspectors are required to have a prescribed qualification. And those inspectors are appointed for the purpose of chapter Roman 3, Roman 4, and Roman 5 of the Act of 1948. At this stage, it may be relevant to mention that chapter 4, Roman 4, relates to registration of pharmacists. Chapter 5 relates to miscellaneous. Which includes imposition of penalty for falsely claiming to be registered, that is section 41. Punishment by unregistered persons, punishment of persons who are dispensing any medicine on prescription of a medical practitioner without being registered. That is chapter 42, section 42. Etc. In the same chapter 5, section 46 stipulates 46 empowers the state government, by notification in the official gazette to make rules to carry out the purpose of chapter 3, 4, and 5. Such rules to be made have what the various spheres in which the state's rules can be made have been enumerated in subsection 2A to 2L of section 46. For the purpose of the instant dispute, section 46 2FF double F is relevant in as much as it is the state government who has to make rules pertaining to the qualification, powers and duties of an inspector. Next. Before further proceeding, this court finds it relevant to take note of another two sections in the Act of 1948. The first section is section 10. Which relates to educational regulations to be made by the Pharmacy Council of India, subject to the approval of the central government, prescribing the minimum standard of education required for qualification as a pharmacist. The second section is section 18, which empowers the Central Council with the approval of the central government to make regulations consistent with the Act to carry out the purposes of Chapter 2. This court finds it very pertinent at this stage to take note of section 18(2)(f), which stipulates in section 18, finds it very pertinent to take note of that section 18 specifically deals with only chapter 2, which relates to the Pharmacy Council of India. And this very aspect can also be seen from section 18(2)(f) in contradistinction to section 46(2)(ff). Section 18(2)(f) deals with qualifications, the term of office and the power and duties of the registrar, secretary, inspector and other officers and servants of the Central Council, including the amount and nature of security to be furnished by the registrar or any other officer or servant. In other words, the qualification, comma, the term of office and the powers and duties of inspectors of the Central Council can be decided, can be made, can be prescribed by the Central Council with the approval of the central government by way of a regulation. However, if this court takes note of section 46(2)FF, along with conjointly reading it with section 26A of the Act of 1948, it would be seen that the prescribed qualifications mentioned in section 26A can only be made under section 46(2)FF of the Act of 1948 by the state government. At this stage, it is pertinent to mention that the respondent state have not made the rules in terms with section 46(2)FF. Of the Act of 1948. Therefore, there is, as on date, no prescription on the qualifications required for appointment of an inspector under section 26A of the Act of 1948. There is also no rules framed pertaining to the powers and duties of an inspector so appointed under section 26A of the Act of 1948. And under such circumstances, the question would arise as to how any inspection to be carried out under chapter 3, 4, and 5 of the Act of 1948 can be carried out. In the backdrop of the above, it is further pertinent to take note of that while the state government is yet to make the rules, in relation to the qualification, powers and duties of the inspectors, the central government, the central council have framed the regulations with the approval of the central government, known as the Pharmacy Practice Regulations 2015. From the very preamble of the said regulations, it would be seen that the power to make those regulations have been traced to section 10 and 18 of the Act of 1948. Or in other words, the power in respect of making regulations for so insofar as prescribing the minimum standard of education required for qualification as a pharmacist, as well as the various other aspects as stated in, as enumerated in section 18.2 A to G, A to H. Which only relates to the Central Council. In the backdrop of the above, let's go now take note of the grievances of the petitioner. The petitioner, number one, which is a state pharmacy council as constituted under section 19 of the Act of 1948, is aggrieved by the inaction on the part of the respondent authorities, that is the state government, in granting the due approval which is required for appointment of inspectors by the state council. The petitioners are further aggrieved by the inaction on the part of the state government in making the rules in terms with section 46(2) FF, thereby prescribing the qualifications as well as the powers and duties of the inspectors. The petitioners, as stated above, is also aggrieved by the rejection of the request for granting approval by the impugned communication dated 28/7/2021. Now let's see what is the justification forwarded by the state government in respect to non-implementation of not granting a justification so forwarded by the state government. The justifications so forwarded are, number one, if there are two sets of inspectors appointed, that is for the under the Drugs and Cosmetics Act 1940, as well as under the State Pharmacy Act, under the and under the Act of 1948. it would result in two sets of inspectors. One, regular inspectors of drugs, and the other, non-government inspectors. And it would be difficult for a pharmacy owner oblique pharmacies oblique drug licenses holders to distinguish between a regular inspector of drugs and a non-government inspector. The second reason is that the government will have no role in the selection process of the non-government inspectors per se. But at the same time, there will be liability on the part of the government if the government grants permission for such appointments by the petitioner, number one. Number three, the appointment of non-government inspectors does not seem to be, as per the appointment of non-government inspectors, as per the state government stand, did not seem to be a proper substitute for ensuring good practice in drug administration regulatory system. And system. On the other hand, filling up the entry-level vacant posts in the cadre of inspector of drugs timely and putting in place a proper monitoring mechanism by the Commissionerate of Food Safety and Drug Administration seems to be the more appropriate policy. In addition to that, the learned counsel appearing on behalf of the respondent state had also tried to justify the actions of not fulfilling the mandate of the Act of 1948 on the basis of Regulation 5 of the Pharmacy Practice Regulations 2015 and submitted that on the basis of that regulation, any inspector can carry out the various functions as enumerated in Regulation 5B, Roman 1 to Roman 6. And as such, there is no requirement for appointment of a pharmacy inspector when inspectors who are appointed under the Drugs and Cosmetics Act 1940 can perform the said act. Drugs and Cosmetic Act division. You have it? Drugs and Cosmetic?
Yes.
Mati diyorsun. I've heard the learned counsels appearing on behalf of the parties and given my anxious consideration to the relevant submissions. In the foregoing portion, in the foregoing paragraphs of the instant judgment, this court had duly dealt with the Pharmacy Act, the Act of 1948. And taking into account that the state government have taken a stand that the drug inspectors who are appointed under the Drugs and Cosmetics Act 1940 would be a substitute or can also perform the acts as envisaged by a pharmacy inspector under the Act of 1948, this court finds it relevant to take note of take note of certain provisions of the Drugs and Cosmetics Act 1940 উপর লিখে দিব হ্যাঁ an act of 1940 বুলি for short বুলি কৰি দিব I'm just coming here. Act of 1940 stipulates who can appoint the inspectors as well as the powers which may be exercised by an inspector and duties which may be performed by him. Section 22 stipulates of the Act of 1940 stipulates the power of the inspectors from a perusal of section 22. It is seen in what premises the inspector, in which premises the inspector can inspect, semicolon, what samples of any drugs or cosmetics that can be taken, semicolon, search any person, enter and search any place, and stop and search any vehicle, vessel, or other conveyance when the inspector has reasons to believe that an offense under Chapter 4 of the Act of 1940 have been committed. The inspector further has the power to examine any records, register, documents, or other material objects found in respect to commission of an offense under the Act of 1940 or the rules framed therein under. The inspector also can require any person to produce any record, register, or other document in relation to manufacture for sale or distribution, stocking, exhibition for sale, offer for sale, or distribution of any drug or cosmetic in respect of which he has reasons to believe that an offense under Chapter 2 have been committed, has been or is being committed. In addition to that, an inspector also has the power for carrying out the purpose of Chapter 2 or any rules made therein under. However, it is very apposite herein to mention that the powers conferred upon the inspectors under Section 22 of the Act of 1940 has no relation to exercise of powers under the Act of 1948, and more particularly in respect to Chapter 3, 4, and 5 of the later Act. It would also be very pertinent to mention that in exercise of the powers conferred under Section 6(2), 13, 33, and 33 capital N of the Act of 1940, the drug rules 1945 have been made. Rule 49 of the rules of 1945 relates to qualifications of the inspectors, and Rule 50 relates to duties of inspectors in premises licensed for sale. From a perusal of the said two rules, Rule say two rules, more particularly Rule 51 of the rules of 1945, it does not show that the drug inspector, an inspector appointed under the Act of 1940, can exercise any powers in respect to the stipulations contained in Chapter 3, 4, and 5 of the Act of 1948. This court also finds it very pertinent to take note of that in spite of the Act of 1940 as well as the rules of 1945 being enacted and made respectively, the Parliament thought it necessary to enact the Act of 1948. Specifically, to deal with the subject pertaining to regulation of the profession of pharmacy. Or in other words, as regards the regulation of the profession of pharmacy, the Act of 1948 is a special act. It is also further apposite to mention that in spite of the powers being conferred upon the inspectors under Section 22, inspectors appointed under the Act of 1940, and the duties, powers and duties so conferred under the said Act of 1940 and the rules framed therein under, the Parliament thought it necessary to insert Section 26A to the Act of 1948 for the purpose of carrying out inspection by inspectors to be appointed by the State Council with the approval, with the previous sanction of the state government, and to carry out the functions, carry out the duties as envisaged in Section 26(2) A to E of the Act of 1948. Therefore, it would be seen that both the acts, that is the Act of 1940 as well as its rules framed therein under, work in separate fields from that of the rules framed therein under, and the Act of 1948 work in separate fields. And under such circumstances, it is the opinion of this court that the inspectors so appointed under the Act of 1940 cannot perform the work exercise the powers and duties of the inspectors to be appointed under Section 26A of the Act of 1948. At this stage, this court finds it relevant to take note of the submission of Mr. D.P. Bora, who laid emphasis on Regulation 5 of the Pharmacy Practice Regulations 2015 to submit that an inspector of drugs appointed under the Act of 1940 can also exercise the powers under the Act of 1948. The said submission is completely misconceived on the basis that these regulations of 2015 was made in exercise of the powers under Section 10 and 18 of the Act of 1948, which, as already stated herein above, are in respect to prescribing the minimum standards of education, as well as the power to make regulations insofar as the Central Council is concerned. Another reason why this court considers or observes that the said regulations of 2015 cannot be made applicable is for the reason that section, insofar as the inspectors are concerned, is for the reason that section 46(2) FF categorically mandates that it is the state government who shall make rules for the purpose of stipulating the prescribing the qualifications, powers and duties of the inspector. In the backdrop of the in view of the above, let this court further consider as to whether the justification given by the state government that there is no requirement of having inspectors appointed under Section 26A of the Act of 1948 is tenable. The first justification pertains to that the inspectors appointed under the Act of 1940 and the inspectors so appointed under the Act of 1948, there would be overlapping domain. And it shall be difficult for the pharmacy owner /drug license holder to distinguish between a regular inspector of drugs and a non-government inspector. And it was apprehended that a parallel drug administration will function outside the purview of the government. The said justification, in the opinion of this court, is not only completely misconceived, but it is also contrary to both the Acts of 1940 and the Act of 1948. Inasmuch as stated above, the inspectors so appointed under the Act of 1940 would exercise powers in terms with section 22 of the Act of 1940 and the as well as Rule 52, na? 51 question will be. As well as Rule 51 of the Rules of 1945, which does not cover the field as is given, as is to be performed by the inspectors to be appointed under the Act of 1948, more particularly taking into account subsection 2 of section 26A of the Act of 1948. The apprehension that there would be a parallel drug administration outside the purview of the government is totally misconceived, taking into account it is totally misconceived. And such apprehension amounts to tinkering with the wisdom of the legislature in enacting the Act of 1940, enacting the Act of 1948, in spite of the Act of 1940 being in operation. Next. The second justification so provided is that the government would have no role in the selection process of the non-government inspectors per se. But at the same time, there will be liability on the part of the government if the government grants permission for such appointments to the petitioner number 1. The said justification, in the opinion of this court, is further misconceived, taking into account that a perusal of section 26A categorically shows that the state council may, with the previous sanction of the state government, appoint inspectors. And as such, the government would certain control as regards granting of the previous sanction prior to granting appointment to the inspectors. Why are you saying that it is to be paid by them, by you?
Paid.
By the government is going to pay?
No, my lord,
Yeah, it is written, na? But at the same time, that there will be liability on the part if the government grants permission for such APS.
yes, my lord, because probably the remuneration or salary that has to be paid by the government, my lord. Because,
You give an undertaking.
no, probably
What probability? You can say on probability, you pass an order, a public order on probability. Where is it say? It is the appointing authority will pay.
but they don't have any fund of their own, my lord.
They don't have fund, then for them, they will know it. Because the moment you pay, there will be scale. They will pay whatever they feel like.
Section 26 is there, if you're not sure to resist this, of the 1948 Act. 26A, subclause is C and D. C and D.
So this will be paid by you.
Yes.
In addition to that, it seems to be a misconception on the part of the state government to visualize that there would be liability on the part of the government if the government grants permission for such appointment to the state councils. Inasmuch as a perusal of section 26 of the Act of 1948, as rightly submitted by Ms. D. Bourgoin, the learned counsel for the petitioner, that the liability to pay for the inspectors, the salary of the inspectors, would be only upon the state council. Next. The third justification so given that the inspectors so appointed under the Act of 1948 did not seem to be a proper substitute for ensuring good practice in the drug administration regulatory system is on the face of it erroneous, inasmuch as the inspectors so appointed under the Act of 1948 powers are only limited to what has been mentioned in subsection 2 of section 26A of the Act of 1948. Such inspectors does not have the powers, would not have the powers as is granted to the powers as would have been granted to the inspectors so appointed under the Act of 1940. Under such circumstances, this court is of the opinion that the order dated 28/7/2021 is contrary to the Act of 1940 as well as the Act of 1948. It is also the opinion of this court that the inspectors appointed under the Act of 1940 cannot exercise the powers under Chapter Roman 3, Roman 4, and Roman 5 of the Act of 1948. And more particularly, the powers conferred upon the inspectors under the Act of 1948 in terms with subsection 2 of section 26A of the Act of 1948. Under such circumstances, the instant writ petition stands disposed of with the following observations and directions. The inspectors so appointed under the Act of 1940 cannot exercise the powers of the inspectors to be appointed under section 26A of the Act of 1948, or for that matter, cannot exercise the powers in respect to chapter Roman 3, Roman 4, and Roman 5 of Act of 1948, and more particularly to the powers so given in terms with subsection 2 of section 26A of the Act of 1948. Accordingly, next, the impugned order dated 28/7/2021, being contrary to both the Act of 1948 as well as 40 as well as the Act of 1948 is set aside and quashed. Number 3. The petitioner number 1 has the power to appoint inspectors in terms with section 26A of the Act of 1948. However, with the previous sanction of the state government, the previous sanction of the state government cannot be rejected or withheld for reasons other than for giving effect to the provisions of chapter Roman 3, Roman 4, and Roman 5 of the Act of 1948. Number 4. The inspectors so appointed under section 26A of the Act of 1948 are to be paid the remunerations by the state council. That is the petitioner number 1 herein. Number 5. For the purpose of giving effect to the Act of 1948, and more particularly, to make inspection, it is the requirement of law there has to be a prescription in respect to the qualification, powers and duties of the inspectors to be made by framing rules by the state government. Under such circumstances, as the Act of 1948, and under such circumstances, as the regulation of the pharmacy can only be made only by the Act of 1948, which is a special legislation. And there can be no the regulation of the pharmacy can only be made by the Act of 1948. The non-framing of the rules, more particularly as regards prescribing the qualifications, powers and duties of the Act of 1948 by the state government, amounts to infraction of the mandate of the Act of 1948. And as such, this court directs the state government, and more particularly to whom? The Commissioner and Secretary to the Government of Assam, Health and Family Welfare Department, to make rules in terms with section 46A FF 2FF of the Act of 1948 at the earliest and preferably within 3 months from the date of the instant judgment. In the backdrop of the above, in the peculiar facts of the case, this court is not inclined to impose cost.
My lord, only one point if your lordship clarifies, my lord, because as per the regulation 5, my lord, the duties and powers.
I made it very clear. That would not be applicable for the state. I made it very clear in the earlier. Didn't I, madam?
Yes.
I made it clear,
yes,
section
yes.
5, regulation 5 would not be applicable. That is under the central regulations. That is why I referred to 10 and 18. All this while what I was, my throat is paining now. Yes.
My lord, but as your lordship has pointed out that the inspectors appointed under the drugs and cosmetics and they cannot perform the duty. My lord, till such date, it has been appointed, my lord, because
I can't. That is not my lookout. Don't do it.
And rules does not provide for that. There'll be a direction, illegal direction, because the rules does not provide.
How do I
It's
do
going
it?
against the rules.
I cannot. That means you are asking me to be the Health and Family Welfare Commissioner.
no, my
My goodness.
Probably.
You do whatever you issue a executive instruction, whatever may be, that these appointments will be made something. This is not for this court. For them to again challenge. Yeah. Don't do inspections as regards this. You are not to do others, you can very well carry out. Only as regards to this fake pharmacist will have a very good sleep for these 3 months at least.
And also possibly the direction has to go to the principal secretary to the government of Assam.
Okay. Principal Secretary to the government of Assam, Health and Family Welfare.
Item 7 to 10.
Yes.
7 and 8, your lordship, I am appealing.
Which one?
7 and 8, your lordship.
What are these 7? Oh, they have given so many files along with me. 7,
Why these
8.
matters are tagged together?
Huh?
Why these matters are tagged together? The chain is somewhat curious. In
Okay.
item
You
num-
are for whom?
I am for the excise department.
What is excise to do with this?
It's an excise tender process initiated by the excise department.
Oh, why are all these matters are there?
Yes, your lordship. Item number 10, your lordship.
Hmm.
The petitioner, his bid was rejected on the ground that some certificate was not submitted.
What?
Some certificate required under the tender.
Oh, these are all excise.
Excise.
Oh, I remember. Yes, yes. There is
So-
some problem with these people.
Yes.
What you have done is some people have been, in some cases, some certificate is something
sir.
in the question.
Yes.
Na?
So far as in my case is concerned,
And in
Proof
some
of-
Tinsukia, they have allowed it, in some place they have not.
Yes, your lordship.
His case.
yes, in
Item
his
number 10, my lord.
Yeah, or something like
taken
that.
ten.
Okay, let us take one by one.
Yes.
The first is item number 7.
7, yes, your lordship.
7. Yes, Prasanto Gogoi.
lordship. In 7, your lordship, issue is your lordship. Proof of bank account, your lordship, they say I have not provided. That's the ground on which your lordship.
So all these matters will be different.
Factually, they are a little different than the.
So far as 7 and 8 is concerned, your lordship, the same issue,
Okay,
bank certificate.
same tender.
Same tender, your lordship, but different, your lordship, shops.
Huh?
Same tender, but shops are different.
They have been rejected on that.
That ground,
But all others are different tenders.
different tenders. sir.
But these is
These
7
7
and 8
and
are
8 from
same
the
tenders.
Tinsukia, your lordship.
Okay. Now your case is Prasanto Gogoi. Same tender. Yours? Same tender.
Yes, Sunit.
Tender is same. But in the tender, do you apply for a particular shop?
Tender is different.
Different. Tender is district wise, your lordship.
Okay, so it can't be same. You are all of you are Tinsukia.
We treat from Tinsukia, 7, 8.
Okay, his matter will be taken up separately.
8 and 9 for the same shop. 8 and 9 for the same
Huh?
shop. 8 and 9 for the same shop.
Okay, in shop, but it is from Tinsukia. It means saves me from writing 4 judgments instead of the making one judgment.
Perhaps even then the grounds on which the challenge is made.
No, that I'll take care of it.
Yes.
That I know how
Very
to
well,
take it.
very well.
Item number 9 was taken by the honorable court, by the way. Item number 9 was taken along with item number 10 by this honorable court on the ground that.
Don't worry, your matter will be taken up. I will make a separate judgment for you. Because you belong to a special category. Because it let us at consent.
Lordship.
Yes, what is
Here,
your
your
case?
lordship, NIT was issued, your
Where
lordship,
is the NIT?
your lordship, page 27. This was dated 29/11/2023.
Page, list of proposed Indian made foreign liquor. I am at Pedigree area. You are Pedigree.
I am in Pengeri, your lordship, PSK
In
6, page 30, your lordship.
Pengeri area, Margarita.
Pengeri.
Okay, invite shop for Iman Tinsukia,
Yes.
page 5, so and so, earnest money, so and so. Okay, this is the page 32, is that notice?
Yes, your lordship. It's
In the intending tender of so and so. Oh, Mr. Pathak, you are the forest department also, na? Now, BTC forest department officials are under BTC.
There is a special principal chief conservator of forest BTC.
Huh?
There is a special PCC of BTC. Your Lord.
And the cadre? Cadre is from where? Where do these people, just for a divisional forest officer, he belongs from where?
Cadre, I believe, your lordship, I just need to.
They may be given, they may be under the control of them.
Yes, cadre,
But
I believe is same.
same,
I just need to.
you just
Verify.
let me know.
lordship, so far as this tender is concerned, your lordship, I will rely on your lordship.
Mm.
First of all, your lordship, the page 34, your lordship,
Page 32?
page 34.
এই তুই এসি তে কমাকচোন বাহিৰ 18 হৈ আছে কোন ওপৰত 21 মানত দিও বাস হ'ব
Page 34 is the overview of eligibility requirement, your lordship, an individual.
E4 anyway an individual
partners-
partnership firm a liability company or a company registered under Iman
Yes.
or subsequent enactment who has proof of filing income tax return for 3 financial years out of the
Is
last
eligible to
4
participate.
financial
I am an individual, your lordship.
so you are individual
Individual. Now, your lordship.
and you have financial years.
Your lordship.
3 financial years
Yes,
you have filed income
yes,
tax.
yes, that is there. Now, your lordship may kindly come to page 36.
Yes.
Terms and conditions of grant of IMFL living license, and your lordship, the terms and conditions for grant of IMFL retail of license shall be governed by the provisions so and so, and government instructions, circulars, orders, office number. The district collector of the respective district shall constitute a tender bid committee with the following members. Now, this is the, your lordship, tender committee constituted. District collector or an additional district commissioner to the district as nominated by the district collector. Now, in our case, your lordship, it was delegated to the additional district commissioner and he headed the tender committee, and other members are, your lordship, at page 37.
Then NIC,
Lordship,
finance and accounts,
lordship. The
superintendent of excise,
and the
subdivisional
subdivisional officer.
of the Iman and the deputy Iman in
Lordship.
respect of shops located in respective subdivisions.
Then your lordship may kindly
Means
come,
there are, number 5 is 2 persons.
lordship. Subdivisional officers and the deputy superintendents of excise in respect of the shops located in the respective subdivision of the district.
So there will be 2. So there will be 1, 2, 3, 4, 5, 6.
Lordship.
6,
Six.
7.
Lordship. Then your lordship, in the page 37, your lordship will find, your lordship, tender bid committee shall open the technical bids on the pre-notified date mentioned in the bid documents. Thereafter, the tender bid committee shall cause to be verified the technical qualifications of the bidder as it deems fit and proper, and shall publish a list of technically qualified persons. They will do that, your lordship. Then your lordship, your lordship may kindly come to page 40, documents comprising the bid. Now, your lordship will find the bids, technical bids shall primarily consist of the following: duly filled up application format as per annexure A. So far as the rest of the requirement is concerned, your lordship, I fulfill, but my problem, your lordship, with the tender comes in this particular form. Your lordship. I will show that, your lordship. Now,
What did you not fulfill?
in the tender form, your lordship, there is a column where I am required to, your lordship, mention the bank account details and also proof thereof, your lordship. Now, they now say that I did
No, in this,
this duly filled up application format.
no,
as
number
annex-
6, which one you did not fulfill?
Lordship, that your lordship, duly filled up application format as per annexure A, your lordship will get that annexure at page 50. It starts from page 55.
Hmm.
Your lordship, and the relevant portion is at page 57.
Complete address,
That is there, page 57, your lordship, 11,
proof
12.
to
your
be
lordship.
submitted, yes.
Details of bank accounts, proof to be submitted. The name of the bank and address, PNB, Punjab National Bank, Margherita, current account number so and so, SBI Hizuguri Savings Bank account so and so. Now, this is what I have provided you. So now they say, your lordship, that I did not provide your lordship the proof of having this, your lordship. That I will come later on, your lordship,
Proof
of having these accounts, your lordship.
is it required as per this?
Yeah, proof to be
As
submitted,
it will be given in number 6, na?
lordship, proof to be submitted.
Submitted. Oh, you did not submit this.
No, I submitted it. So they
What?
say I am not submitted.
Huh?
I will come to that, your lordship.
Okay,
before-
you come.
Then your lordship will kindly come to page 47, your lordship.
Yes.
47, serial number 13. Rights of district collector in regard to EBD. Notwithstanding anything contained in this EBD, the district collector reserves the right to accept or reject any bid, and to annul the selection process and reject all bids at any time without any liability or any obligation. Then, for such acceptance, rejection, annulment, and without assigning any reason there, this collector shall reserve the right to reject any bid if at any time any misrepresentation is made or uncovered, or the bidder does not provide within time specified by the district collector the supplementary information sought by the district collector for evaluation of the bid, your lordship. This is important, your lordship, that they can seek supplementary information, your lordship. Now, your lordship will kindly come to page.
No, where is it mentioned that there is a supplementary information can be taken
Lordship,
in the bid?
your lordship, I will show that also, your lordship. Your lordship, deviations in terms and condition of the bidder, your lordship. It says, your lordship, tender committee,
Where?
page 49,
Deviations.
serial number 90.
Overseeing the bid.
No
Reserves
deviations
the
in
right
terms
to
and
bid
as laid out in
minority.
the bid shall be accepted. The tender bid committee overseeing the bid reserves the right to waive minor irregularities, your lordship. Now, your lordship will kindly come to next. Your lordship, page 52. Clarification from bidders, your lordship. The technical bid committee may, at its sole discretion, contact the bidder for clarification of the response. The tender bid committee reserves the right to verify the credential, including documents, declarations, self-certifications provided by the bidders by its own means and method. In case the tender bid committee receives feedback contrary to the response of the bidder, or is not satisfied with the compatibility of the experience with the required standard expectations, then the tender bid committee reserves the right to form its own opinion and even reject the bid and forfeit the EMD. The tender bid committee may use other sources of information in bid evaluation as required, your lordship. Now, your lordship, I submitted this document, this form, your lordship. What they did, your lordship will kindly come to first, your lordship. Bank certificate, your lordship, page 117.
117.
What I have submitted, your lordship. This is by the Punjab National Bank, your lordship. This is to certify that Mr. Prasanto Gogoi, son of so-and-so, Ramesh Chandra Gogoi of number Borgulai Margherita, Ninsuke Assam, is a reputed customer with good financial standing. We shall be able to provide overdraft credit facilities extent of so-and-so only to meet the working capital requirements. The certificate is issued without any guarantee or responsibility of the bank and its official, your lordship. Now, I submitted this, your lordship. It did not mention, your lordship, my account number. Otherwise, your lordship, if we correlate with what I have mentioned in my form, page 57, your lordship.
Not only the account number, it doesn't also have a date.
Which, your lordship?
This document?
Date is there, your lordship. Seal is there, your lordship will find.
Where?
Just below, your lordship, that's the seal.
Where? Is the date?
Date is there, your lordship, and that is not the issue, your lordship. Otherwise, your lordship.
No, this is date is important. This is 2/12,
12, your lordship.
20.
23.
And when was this bid submitted?
This was, your lordship, bid was issued on 29/11/2023, and your lordship, last date, your lordship,
When did you submit your bid?
lordship. my bid was- On the last date, we have submitted.
When?
Your lordship will kindly come to page 58, your lordship. It was. Declaration is signed on 27/12/2020.
And this is dated 2/12,
Lords,
23.
lords.
And when was the tender issued?
Tender was issued on, your lordship, 29/11. 29/11 tender was issued, 2/12, your lordship, we get that certificate, your lordship. We submitted, your lordship, thereafter on 27/12. Now, your lordship,
And what was about the other bank account?
lordship, that is, your lordship, for so far as the other bank account is concerned, your lordship, that is at page 60. This is, your lordship, the
Page?
bank, page 60. 60. That is in respect of, your lordship, this is a bank guarantee, your lordship. 60, yes, I have your extra certificate. So far as the other bank account is concerned.
The bank guarantee only.
Guarantee. That certificate, so far as the other bank account is concerned, we have relied on this bank guarantee, your lordship. We have not submitted any, your lordship, other certificate, your lordship.
So this doesn't show anything.
Lordship, lordship. That is, your lordship.
Then
Lordship. Now, your lordship will kindly come to page 118, your lordship. Now, they accepted my technical bid, your lordship.
Then
They accepted my technical bid, and this is page 119 is the minutes of the meeting, your lordship. Your lordship will kindly come to page 120, Pingeri TSK 6.
you have been considered for financial.
Lordship, financial. Now, your lordship will kindly come to page 122, your lordship, 123, your lordship. Then again on 22nd February, I am informed by an email, your lordship, that you are informed that your bid for the above tender has been rejected during the technical evaluation by the duly constituted committee for the reason technically disqualified. Once they held me to be technically qualified, then, your lordship, by a review, your lordship, they held, your lordship, page 124 is the minutes of the
Where is the other person? Your name? Page?
page, your lordship will get it at page 126. Serial number 29. Prasanto Gogoi, rejected. Rejected due to non-submission of proof of bank account.
So you have not given any submission, any document to show that there is a proof of bank account.
That is their case, your lordship, but, your lordship, that
No,
is
there is my case also. I am also putting it.
lordship.
It is not there. How do you say that he has a reputed? How do you know whether you have a bank account there?
Lordship, PNB Bank has very specifically certified, your lordship, that I have an account, I am a customer of that bank account, I have sufficient means, your lordship, financial means there, your lordship, and they are ready to, your lordship, gives amount of loan amounting to rupees 50 lakh or something.
Why didn't you give your passbook? That's all. Why
No,
didn't you
that
give a certificate?
Lordship, that is there, your lordship. We
That
could
would have been enough.
But, your lordship, will kindly see, your lordship. The first of all, your lordship, the issue is, your lordship, that once you accepted my bid, your lordship, holding it to be technical, I am technically qualified, everything is in order, your lordship. Then suddenly you review it, your lordship. Why? Why they have gone for that, your lordship? They have given explanation in the affidavit, your lordship, saying that there is some complaint, your lordship, by some people, your lordship. Now, those complaints not related to me, your lordship. Those complaints, your lordship, one complaint, your lordship, will find that complaint is in respect of some other, your lordship, shop, your lordship. It was written on 12th, and it was given on 16th, your lordship. And then, your lordship, another complaint, that complaint even does not mention what is against which shop he is raising this complaint, your lordship. based on these two complaints, which has nothing to do with me, your lordship of the.
No, if somebody's technical bid has been accepted, is there any estoppel
No,
that no, it cannot be cancelled?
no, your lordship, that,
Later on, isn't it an evaluation complete? A one evaluation, technical, financial, yes, they are part out there only for the purpose the technical will be looked upon by one person. And then if there is a mistake being done by the technical, but the very technical committee says, oh, there is some mistake. We can very well look into it.
lordship will kindly see, your lordship, that that power is there, your lordship. I am not saying that if there is a glaring illegality that has been committed, your lordship, this is not a case of this nature, your lordship. The object that is sought to be achieved, your lordship, by seeking my and your lordship will kindly see, your lordship, that's why I have pointed out, they have ample means. There is a provision that they can make additional informations, they can take additional informations.
There is no provision that they must.
No, your lordship, they can, your lordship.
can.
There cannot be a must, your lordship, in such situation, they can.
No, there are many tender clauses where you find that if there is any discrepancy or on a certain historical documents, you looked into it, given they may, the tender committee can also or should inquire. These are various aspects are there.
Lordship.
But here, the framers of the tenders or big people have made it in such a manner, you were asked to submit the proof of documents. Very well, you have a proof as of now. Whether that is you have put a SBI bank account number, there is no statement to the effect, no document. So that is not there. How many bank accounts were to be required?
One, your lordship. I have,
But that also is no proof.
but your lordship, PNB Bank, once your lordship clarified that I am a bank account holder, your lordship, that has, in my humble submission, your lordship, that has substantially, your lordship, means substantial compliance of the terms of the tender, your lordship. And your lordship, that is why, your lordship, during first evaluation, your lordship, they have accepted this, your lordship. Now suddenly, your lordship, without any complaint so far as from none of the bidders, your lordship, they have gone for review, your lordship. That's my case, your lordship. Now, your lordship, you need a bank account, your lordship. So far as this bank account is concerned, your lordship, what is the purpose for which they need the information of the bank account? That I have certain financial capability to do the business. Now, if your lordship bank certifies that yes, he has a bank account, your lordship, in our bank, your lordship, and I am saying that this is my bank account, correlating both these documents, your lordship, then your lordship, it means, your lordship, I have substantially complied with the terms of the tender, your lordship. Had it been a case, your lordship, that this.
Now, can this court hold that you have substantially complied?
In my humble submission, your lordship, my submission will be, your lordship, yes, your lordship. But rest up to your lordship.
No. You are to therefore bind me with some judgment of the Supreme Court or something to show that yes, I should exercise such a law.
No, your lordship will kindly see, your lordship, there are cases, your lordship.
Huh?
Now, your lordship, so far as the tender jurisdiction is concerned, your lordship, law has, your lordship, developed to an extent, your lordship. Normally, your lordship, courts will always be reluctant to interfere in these matters, your lordship. That's for your lordship. But if it becomes apparently unfair, your lordship, if it looks apparently irrational, your lordship, in my humble submission, this court under 226 jurisdiction can always interfere. And
Understood. What is this apparent unfairness?
That
Because
is-
you were asked to give your proof of your bank account. You did not.
no, your lordship, my bank.
You say that the bank, somebody may trace it out, okay, where the bank lies? Where is the account, where is the branch? Oh, it is in
The
Chennai.
branch, your lordship, that particular branch says, your lordship, issued that certificate, PNB.
Where is that account, bank account, where?
Punjab and National Bank, your lordship.
It is too big.
Lordship,
Punjab and then is Pan India. Which
lordship,
is the branch?
Margherita, your lordship, that 117 itself, your lordship, and your lordship will kindly come to page 57, your
Oh,
lordship.
no, where is it say? Is the reputed of our branch?
Lordship, issued by the branch office of Margherita, your lordship.
Understood. It may
Top,
be.
your lordship. This is certified so and so Borgoa Margherita Assam is a reputed customer with financial standing and branch has issued it. And I have, your lordship, your lordship, 57, I have mentioned, your lordship, name of the bank and address PNB Margarita. So if we correlate this with this, your lordship, that is, your lordship, substantially complied. Now, your lordship, what is the object they have, and your lordship will also kindly note that I have offered higher value, more than 10 lakhs than the person who has ultimately got selected, your lordship. So far as my bid is concerned, your lordship.
No.
No, that is not a ground,
That is not a consideration for the state of Assam.
lordship.
State of Assam has got lots of money. They are not bothered. In that matter, one BTC matter, what they have done is a person given at 2 crores initially, they cancel it and then give him at 17 lakhs by holding a secret tender. So they are not bothered about the money. Money is not the question for them. Maybe a consideration for you, me, and everybody, even the lawyer. But for BTC or these people, they don't have anything. For them, money is not the consideration. The consideration is you have to strictly apply as per law.
No,
10 lakhs or they may give him at 1 rupee also.
lordship, that is.
And apply, say, the Dotto Associates, we never fixed it how much money is there. You may have quoted 60 lakhs. Okay, we may forego the 60 lakhs for not giving the proper bank account branch number or passbook. We forego it. We are not concerned with money. We are on the transparency.
No, so that, your lordship, if going by the principle of transparency, your lordship, their action is probably, in my humble submission, your lordship, not transparent. And your lordship will kindly see the tender conditions. If we look at, your lordship, why this power is given to waive the minor irregularities, your lordship, to them. They could not have given this power in the tender, your lordship. That was given, your lordship, so that, your lordship, the competition become more, your lordship. It becomes more competitive, the bid process. That's
But
what
where do you end the line? Where do you end the line for
line will be ended there, your lordship.
Where? Mr. Bottako, let us put you in this position. here.
Lordship.
Where do you end the line?
End line will be ended there, your lordship, where, your lordship, if
Whoever gives more money.
no, your lordship, if there had been, your lordship, no certificate, so far as my case is concerned, your lordship, saying that that line is not that he is a valued customer of the bank, then, your lordship, I would have no case at all, your lordship.
Okay.
And second, your
Now,
lordship,
Mr.
now-
Bottako, tell me one thing. When was the financial bid over?
the financial bid was opened on, your lordship,
26 to
26 to 2024.
And when were you rejected after being technically qualified?
Your lordship, 22nd to 22 to 2023.
22?
To 2023. On that date, I was informed. 24, your lordship.
24 to.
22 to 24, your lordship. Now, your lordship,
And as per them, when was the technical bids after being qualified or whatever may be sent to the price bid committee?
that they have not mentioned, your lordship,
That
but
is a
your
very
lordship,
important
but
consideration.
the price bid was opened on 26.
It was open, it's a different thing.
After 4 days, your lordship, price bid was open.
How do you know it was opened on 26th?
Lordship, that, your lordship, that they have also mentioned, your lordship, and LOI was also issued on 26 too.
Price bid was open on 26th, how do you know?
Lordship, that is my information, because they will be in a more better position to
Was it open prior to that?
technical bid, your lordship.
Price bid, was it open prior to that?
No, your lordship, prior to that, price bid was not open. Price
So-
bid was open after 20.
Was the price bid open in your presence?
No, price bid, since I am technically disqualified, the question of my presence.
You were initially qualified.
But after initial qualification, your lordship, they did not go for opening of the price bid.
So under such circumstances, was the price bid open in presence of anybody?
Not in my presence. So far as other tenders are concerned, successful bidders are concerned, probably they may be present. Since I am technically disqualified, I can't, your lordship.
Okay. Mr. Pathak, how do you open the price bid?
Lordship, price bids, there is a process laid down, your lordship. I will just.
Because normally there is a date being fixed in
Yes.
all tenders.
Yes,
I don't know here.
Date
Because
was
here
fixed.
there is no date fixed. So how do you open the price bid?
yes, your lordship. Process is there, Your Lordship. Just can you give me a moment?
113.
Is the price bid open in front of everybody? Because the technical bid is normally open before other tenders. Is the price bid open in front of everybody?
Yes, Your Lordship. Lordship may come to page number 54 of the writ petition.
64,
50.
54. Shall be evaluated deposit of cylinder areas when the finance bay only will be open online. Who have qualified in demand the bidders, namely prices so and so and others of the. So it is online open. So it was open only on 26th.
Yes, Lordship, the bids were opened on. Yes, Your Lordship.
26.
26th.
Then why is this minutes recorded on the
Lordship, it was opened on 22nd. Your Lordship.
price bid?
Price bid was opened on 22nd.
There the question arises. There you get the answer.
It is at page number 159.
There you get the answer. Your disqualification comes on 24,
22nd.
your
22nd.
22nd. And on that date, the price bid is open.
Open. This in.
After making you qualified.
Disqualified. Disqualified. On 13th, I was qualified.
Now, you were disqualified at what time?
Time, Your Lordship, that time.
Message?
Lordship. Message is there, Your Lordship.
Right?
That email was received on at Your Lordship, 22nd
Now,
February.
when was it sent?
On 22nd February 2024 itself, Your Lordship.
Nah, there will be a time.
11:51.
And when was the price bid open?
Time is not reflected, Your Lordship, in this minutes.
Hmm.
The time.
129 maybe some, page 129. 3 PM.
129, where?
Created date times 22nd February at 3:50 PM.
This is generated. I'm not on generation. I'm on the question of when was it open? Because why is this minutes prepared on 22nd?
It was prepared on 22nd.
So it was prepared on 22nd. Why?
Okay, what did
This
happen?
was prepared when? This is very relevant.
22nd.
So this was prepared on 22nd. What time?
In fact, that those minutes at 22nd, which were prepared on 22nd, which starts at page number, copy is there, page number 155 also. The very last page of those minutes, Your Lordship, reflects that the financial bids will be opened after that. If your Lordship has the last
Where is
page.
your rejection?
Yes.
Rejection, Your Lordship will get it at page 124. And page 126.
No. Your information of rejection.
That was 123, Your Lordship. Your Lordship will get at the top 11:51.
Where?
At the top.
No. This is a mobile. This is a printer from a mobile.
Lordship.
This is a screenshot. Okay, let me come back.
Lordship wants the minutes, Your Lordship.
Let me go into the minutes.
Minutes are there. We have enclosed it to the affidavit in opposition. The minutes Your Lordship will have at page number 155.
155.
Yes, Your Lordship.
That is already a part of it. Yes, that is it. I was looking.
I have
for it.
already.
So when was this prepared?
This was, it doesn't say the time, Your Lordship, but it was prepared on the 22nd. And the last page of those minutes, Your Lordship, reflects at page number 159 that the financial bids of the accepted proposals as stated above shall be opened on 22/2/2024.
Where?
Page
Page number
150.
159, your lordship.
159. During scrutiny, the bids which have been uploaded online have been scrutinized, which is also available in the public. The final bid of the as stated shall be opened on so and so. And your rejection is when? When is the rejection as per you?
20.
Prior to, I do, the time is, I have requested them, they have not given me the exact time. But since the financial bids is, it's open, it opens online, the timestamp is available. Your lordship.
So who rejected them technically?
The same committee.
So there must be a minutes there.
Yes, the minutes are there, your lordship.
Where?
It was. Lordship will have the second page. Updated at 2:59 PM. Technical evaluation summary minutes. These are the
Where is the technical summary? That's a PDF document.
that document is there, your lordship. It's a part
Where?
of the record. That is at page number 154. Your lordship. 150, 155.
So this is based upon the instruction by the district collector. Where is that instruction?
The instruction is not a part of the record, but we have made a statement on affidavit.
No. Where is the instruction? Instruction came when? That is a very relevant aspect.
That document is not a part of the record, your lordship, but the complaints are. After evaluation on 13th, the complaints were received on 16th. We have made a statement at paragraph number 7, your lordship, the affidavit officer.
Well, kindly come to page 155. Tinsukia Kailashpur.
Yes, sir.
One Rumi Gogoi was accepted.
Yes, sir.
Bidder has submitted all documents.
Yes, sir.
Was he rejected earlier?
You can check your lordship. It's there. He was accepted, he or she was accepted earlier also. That is at page number 147.
Hmm?
That is at page number 147.
Hmm.
Kailashpur. Rumi Gogoi was accepted, his bid was accepted earlier also.
So you did this re-scrutiny at 2:59.
Was uploaded on the system at 2:59.
And then Immediately you open the price bid.
After that, the price will show.
When did you inform them?
We were informed, your lordship, email with as at 3:16 PM,
Huh?
3:16.
So immediately after opening of the financial bid, you inform them. So when did the deputy commissioner request
That-
you?
Though statement has been made at paragraph number 7, it's a that para 9 of the para 9 of the petition that is there.
Hmm?
Para 9 of the petition, is there.
Of the writ petition?
Yes.
Time of receipt of the information, madam, page 10, para 9.
Of the writ petitioner?
That's when I was informed, not when deputy commissioner died.
That in when the deputy commissioner instructed for a re-scrutiny, that date, your lordship, though we have made a categorical statement on affidavit at paragraph number 7,
When?
that after because the complaints were received on the 16th. The earlier evaluation was on the 13th, your lordship. So it was definitely after the 16th, your lordship. The instruction was given by the deputy commissioner, into which the re-evaluation took place on the 22nd.
Now, when the technical bid has been accepted by that committee, doesn't it amount that the committee has accepted these documents?
It does.
If that be so, it's on the basis of a complaint you have exercised the discretion.
Yes.
So isn't it the author of the document initially thought
Yes.
that the document was, the tender which was submitted was in accordance with it?
Yes, initially, that was the conclusion drawn.
So on the basis of some complaint, you have changed your decision.
So, your lordship, the complaint admittedly.
So the author never thought that it was a requirement, but it was subsequent to that, on the basis of a complaint, you have thought it.
Admittedly, the complaint was not regarding his bid. The complaint was regarding another bid. But since if we did what the deputy commissioner limited the re-evaluation to one specific bid, your lordship, that would perhaps vitiate the entire process. So he directed that the
So did the district commissioner formulate the rules? The NIT
NIT, your lordship,
is being done by the excise department, if I'm not wrong.
under the excise rules, your lordship, the district collector is the license granting authority.
Okay, but who issued the tender?
The draft tender, your lordship, was formulated and given to every district by granting them the liberty to make changes if necessary. So it was issued by the district commission.
Are you saying that the district commissioner has the power to make the tender?
He has issued the tender.
He has issued the tender is a different thing. Something like the district commissioner has the power to issue the tender for the fishery also. But it is overall under the control of the government of Assam. The government of Assam makes the tender.
Yes, this case also the draft tender was prepared by the government of Assam and it was provided to the district commission.
For issuance of it.
But it says that it's a draft tender and he's given the liberty to
Where?
make additions.
Show me that.
Lordship may have page number 142 of the certificate in opposition.
Frequency and judicial plan, then government has recorded for processing the bids. Which plans to be done. Where is annexure one?
Annexure A, your page 142.
Annexure one is this. Now, exemption shall be granted to cover process consisting of the technical demand. Model draft document is enclosed here, shall be filled up with the required data requested for district after finalization of data sheet. Where is the entire document?
The document, your lordship, the petition has already enclosed it.
And this entire document, page 18, the document of 18th of September, along with the draft document.
The draft document is the document which the petition has.
No. Show me the entire document, because this is a very important document, because this touches on the question, because on one hand, a committee which consisted of 5 members, which was the committee as per the NIT, had finalized it and said that these people are there. Now, if it is on the instructions, can the instructions be given by the district commissioner to avail it and look into it? Because here is the case, because if I am to apply FCONS, it is the understanding of the author. The author of the document says that, which consisted of excise officials, they categorically come and say that this is the thing, we accept it. On the basis of certain complaints, you may have waived it. You may accept, you may not accept. These are, then it will be the tenor with which he is submitting. You see, although this aspect of what you call mandatory or directory conditions have already been done away with. The PUDA ties no longer exist. But with FCONS, if we bring on FCONS out here, if the authority have accepted it initially and hold it technically, can on the instructions of the DC, it can be re-scrutinized. That is an important aspect which need you, because you have not done it earlier.
Yes. Lordship, in
For
fact,
that, I think we are required to have a look at this entire document.
yes. Otherwise, the I'll request that the department produces the records, but the tender itself, your lordship, does grant some powers to the DC. And the rules also provide that the tender process is to be conducted by the DC. Your lordship.
Understood, very well.
So
Tender
once
process
he's
is
the
there, but
author-
why did you frame, why out there in the tender document, you said these are the members who will going to look into it?
Yes.
And these very members, which included initially, where is the first one? And on 13th? Initially on 13th, where is the page?
That is a 146, your lordship, it was considered.
146.
46.
No, 146 is the first one.
Petition 119.
146. Yes, 146 is being signed by the additional district commissioner. The superintendent of excise, deputy excise, treasury officer, district information of all these 5 are there. So all this is the tender committee. So all have accepted it and can at the instance of the DC, this can be changed.
Lordship, the evaluating authority and the author of the document.
Author of the document, therefore, I am saying, who is the author of the document?
Author of the document
Is the commissioner.
is the commissioner.
What is to be filled up? That is why I am saying, why I am asking for the 18th document. Kindly see this. A model draft, page 142.
Yes, your lordship.
The bid is enclosed herewith, which may be filled up with the required data pertaining to your district after finalization of the data sheet as provided at page 7 of the draft bid. So only that is the only thing which is being permitted to the DC to do. A sheet showing the important information data to be filled up by the district collector is also enclosed herewith. However, the same is merely an indicative one and not exhaustive. So therefore, this document will give a light as to what is the source of, what is only the requirement to be filled up by the DC. Does it include anything which he can incorporate a condition of?
I understand what is calling from the law.
Because if we are to apply FCons, because the other side's main case is FCons.
Yes, sir.
The FCon says that paragraph 15 that the author of the document in this court should not touch it. Very well. But when the author of the document has accepted it initially, can it be said so?
Perhaps what will also have to be adjudicated by your lordship would be whether the evaluation committee, whether it is the author, whether it is the author of the document or whether it is the DC who has only delegated his powers of evaluation to the.
No, it is not the DC who has given. Kindly see who is they are not the author of the document. Author of the document is the Commissioner of Excise.
He has only prepared a model draft, you know.
Understood? It is the government which is the author of the document. Here the DC head and the government in becoming the author of the document, the draft, have made these people a party. The district collector of the research shall constitute the tender committee of so and so. Technical tender bid committee with the following names. These are the bid committee who will be looking into it. The DC was not present on that date. Thereafter, the DC comes up with a new say that kindly, these are the objections we have received, kindly go through again re-scrutiny.
That is what is happening.
Once which have been accepted, that means they have already waived that or said that, okay, this is a directory for which. Once they say it to be directory, now therefore the question which is involved before this court is not the question of understanding, but the question is when the authority have already accepted it and held it to be a directory, can they later on change it?
That can be.
That is the only scope which is left after FCons. Then only, otherwise I can't touch it, whatever may be. That is why I looked into it. That is the only scope on which I can look into it. Bringing in FCons. Otherwise, FCons is the main problem or the galaxy. Normally, if you see these judgments of FCons, galaxies, these have been passed on the context of which is being done by that authority concerned.
Here that the difficulty is that.
Yeah, the difficulty, can you therefore apply FCons? Because their basic case is FCons.
Here the authority has delegated its evaluating powers to another body.
Yeah, so that is why. Because the power is to be done. Because tomorrow, if we can say, we say, yes, the DC is the author, it will have far-reaching consequences. Because after all, DC may be the settling authority, like the fishery rules. The DC may be the settling authority, but the power is on the government. On behalf of the DC, on behalf of the government, the DC does.
I just wanted to place this before a lot. The
Yeah.
rules were amended, the excise rules,
Ah.
which lays down the process in which this the tender is to be conducted.
And I'll require that document from the DC.
Yes, sir. Lordship may have the amendment to rule 114A, which is at 3711, page number 3711. It starts at 3711. Lordship may turn over to page number 3713. We are, Lordship, if I may draw your Lordship with rule number, sub-rule number 12. At page number 3713. After laying down the process, the district collector shall be the authority to conduct the process of selection of successful bidders for grant of licensee, provided that the excise commissioner Assam with prior approval of the state government may authorize any other official to conduct the selection process and may also authorize any collector to conduct the selection process in more than one district. So, your Lordship.
Yes, therefore the power to make the selection is may be given. It shall be the authority to conduct the process. They will conduct the process of selection. But who will make the rules, the document?
Document has been made by the department.
Therefore, the author of the document is the department.
I understand what is falling from the law. I'll get that. Of 18th, that
So
document. will be
unless
signed.
the author of the document comes up and says that this is the requirement of law, can the other people, once it has been accepted, the technical bid has been accepted, can it be looked into?
Yeah, the commissioner has not filed his response.
No, because there is another judgment which I have passed, wherein the technical bid was accepted initially, but later on it was cancelled because there was a mistake which was committed. Some matter, I forgot, some judgment I have delivered. There I have dismissed the petition on the basis that this is the same authority who have done it. And that very authority said that we made a mistake in doing this. And as such, we are rectifying it because this particular thing has to be there. And the reason assigned why this is required, without that it cannot otherwise be a compatible tender. So this is on which it is to be looked into.
So the 18th September document will be critical. I'll get the.
Yes,
I'll
18
get the entire
September.
records. In.
Yes, entire records, along with that particular document which the DC has written.
Perhaps, maybe wrong. Perhaps affidavit from the commissioner would also be necessary since he is the author, because an affidavit has been filed by the DC establishment.
Now, DC has done it. He has said all these things, but the question is, you are appearing for the excise.
But yeah, I'm appearing for the department, but the department has
The
not
department is the excise.
filed it. Department.
The DC is, therefore I'm saying it's like the fishery rules. He's the settling authority.
Settling authority.
He will do everything. He will settle everything. But the power, however, has to be derived from the government. The government has the power to settle. He's only delegating it to the DC by these rules. So it has to be from there. Okay, when do we have it?
Yes, as per your lordship.
No.
And time that may be taken by my learned friend, your lordship,
Huh?
in getting the instruction. Time that may be taken by my learned friend, your lordship, in getting the instruction.
But this is the only way out to get out from FCONs. Otherwise, you know, if they come up with that, to that effect, that the DC has the power, then it's okay. But otherwise, there is a problem out there because once it has been accepted by them, can the DC supersede that acceptance? I would have understood the commissioner of excise writing that letter. That look here, this is the thing, you cannot do that. This is a condition, this is not there.
It stated in an affidavit that it was the DC.
So understand, can the DC do it?
Very good. Very good.
And other people? Yours rejection where? Say similarly. Huh? Responsive. Then?
The financial bid, I became H2.
Ah.
But immediately after the technical bid, I had submitted representation that the particular the respondent number 5 who has been selected, he did not submit certain documents. So therefore, his technical bid ought not to have been accepted. So that was not responsible.
So the respondent had a problem.
He did not submit certain document as per the requirement of the commission.
Where is it? In your means, it's
Mine
okay,
is-
but I think it is the same one, same Tinsukia, na? Which one is that? Your shop is which one?
Villa Pukuri,
TSK 10 years.
ESK 10, Gilapukuri. Okay, Rajwa. Manoj Agarwal,
I am Pallabjyoti Goswami.
you are?
Pallabjyoti Goswami. Page
Gilapukuri is who?
Page 63.
Gilapukuri has urban.
Urban.
Oh, no, both.
Gilapukuri has a number of successful.
No, you are which one? TSK 10.
TSK 10.
You are Pallabjyoti
Goswami.
Constructions, accepted. Manoj Ranjit Mishra rejected.
Rajdeep Rajkuar turned out to be the H1 bidder.
Huh?
Rajdeep Rajkuar, 38 years.
And even this Manoj Agarwal, he is.
Now, why is this division out here like this?
That line, your lordship, perhaps has fallen by.
Okay. Now, Rajdeep Rajkuar has been found to be here. Now, he is H1.
He is H1. Even Manoj Agarwala, his, my lord, bid has been accepted, but he also, my lord.
So what is your objection as regards Rajdeep Rajkwa?
Rajdeep Rajkwa, firstly, my lord, as per the eligibility criteria as well as the bid documents, the proof of submission of the income tax as well as balance sheet to be duly certified by the chartered accountant. That has not been done.
So they gave the certificate, but not the certification,
They have just given the return and
but without the
balance
certification.
without the certification as well as with the balance sheet without the certification. That is one.
Yes.
Secondly, my lord, the professional tax clearance certificate is necessary. Professional tax, not only the professional and civil.
Now, if that be so, what is the stand of the state as
But
regards
they-
him?
They say that income tax return as it is my lord, system generated, so it need not be certified. No
But
return.
whether it was mentioned in the conditions that it has to be certified.
You may have a look at the condition. Perhaps that will.
So it from me, from this earlier, yeah,
I'll show it from there.
documents to be submitted, technically are duly filled so and so
First, the
undertaking.
clause two, my lord.
Copy of the income tax returns along with balance
Yes.
sheets and statement as certified by the
Chartered account.
Yes. So without that, how is it possible?
Stand taken was what the evaluating authorities have stated in on affidavit is that since it was a system generated document and it can be verified online, your lordship, there was no requirement of having it certified. They basically held this condition to be directed. They relaxed it a little. That's it. Since the IT returns are system generated, they were satisfied with the documents provided by the fund return and they accepted this.
And did he submit a representation
Yes.
to the deputy commissioner?
Correct.
And did the deputy commissioner ask the scrutiny committee to look into that?
He submitted the representation after the rescue.
Huh?
He submitted the representation after the rescue.
Okay, and not before that. You didn't submit before that. Because this was done on 13/2.
But, it was done on 22.
20
Yes,
rescrutiny.
after rescrutiny. It was done
But then first scrutiny was 13/2. So did you submit after 13/2? So in 13/2, he has been shown to be qualified.
Yes. Yes.
Then if you have submitted that to it, why didn't you object then? You knew it. You never filed a petition or did anything to the effect. Why did you allow it to happen? There the problem arises. Therefore, I am saying again, Mr. Pathak, the fact that they have accepted, tomorrow can the deputy commissioner now say, if they have written it to the deputy commissioner, then look here, what you have done is wrong.
In fact, that loan case which your lordship has set aside, what has happened? There, in another district, that evaluating committee held the same condition to be mandatory and rejected that person's bid because he did not submit.
The
the
certificate.
returns are
No, there
certified by
is
the-
actually saying, strictly speaking, this is a requirement because today you take out nowadays every order of the court that yesterday there was an order being placed before me. Like our order has some QR code and all, you can very well verify from here. But there are many orders once passed in the district courts which it is not there. Then can this court look into it? Okay, I can very well verify.
Our rules say that
So it has, when the rule categorically says certification required, every aspect, whenever you submit your income tax certificate, there is a requirement. But you have waived it, okay, that you can do it, being the author of the document. So if you can waive there, why not here in Mr. Bartakul's? So that is the main catch.
perhaps in that matter, what will perhaps the other matter which your lordship has kept aside for Sonitpur,
Uh,
there the same clause has been held to be mandatory by another evaluating authority.
No, if it is held to be mandatory, it's okay, right?
Yes.
Rightly
If the
done so.
authority, yes, your lordship.
Therefore, I'm saying, and there is no interference by the deputy commissioner.
There is no interference.
But here is the case, there is an interference by the deputy commissioner. How does he do it? and asking the scrutiny, going for a re-scrutiny. And that too at the last hour. Hello. Matters being heard at length, this court is of the opinion that a perusal of the records would be required for the purpose of arriving at a just decision in these writ petitions. Accordingly, this court fixes this matter before vacations.
Very good.
Time, okay. On 26. On 26. 26/9/2024 at the top of the list.
Interim orders still for
Interim orders. Because again, there your problem arises. Your problem arises, you should have approached on 13/2.
Submitted within 10 days, madam.
No, but you did it after everything is over. You knew it on 13/2 online,
That instruction I will do.
like everybody else did it. Or you may see in other cases where there are objections being given just in this case, there was no objection in his case. Mr. Bottako's case, there was no objection as regards bank account details being not furnished. But there was an objection made in some other, wherein the district commissioner asked them to look into this, and then they did the re-scrutiny. So you have a look at those documents out there as to whether in any other case in Tinsukia, it has been mentioned about certification not there. If that is there, this should have been applied.
Can it be?
Okay. 24th. You get it? Yes, Mr. Chaudhary, your matter.
2 to 5, fixed at 2 p.m.
The scope of 226 has been reduced a lot in the
MP Power Corporation's case, I think it is reiterated. MP Power Corporation case, I think Justice Joseph and Justice Rishikesh, that's a good judgment.
Those are there, but the problem arises there. Now, how do you?
That is a thin line.
A thin line you have to. But this is a very interesting point which has been developed. That if the authority, because Podar's tires have already been.
Now, because of the Honorable Justice.
G.J. Fernandez.
No, not G.J. Fernandez, Miller. CCL. The Honorable Justice Madan Lakur's judgment, where virtually Podar still has been.
It has gone. So therefore, once it is being accepted by the tender committee, then it would be deemed that they have accepted.
That point has been reaffirmed in so many judgments.
And many judgments.
That court will give due deference to the views of the employer.
In this case, interestingly, the view is of the
Deputy
commissioner, who is a delegated authority. Can that be taken it when the author is the commissioner of excise?
Employer.
So let's see how. Very interesting point. Yes, what happened in this case? Any amounts got? Anybody?
My lord,
Word pass. Now there is everybody is asking for money.
my lord.
Everybody is asking for money.
Oh, my lord, yes, everybody is asking for it.
Then
Then they have to go to the authority for apportionment, my lord.
the amount is already there. They mentioned that the requiring authority and so has requested to deposit there, but the fund is yet to be placed by requiring department. A copy of the award is enclosed. So the award is passed. So I think
Award has not been passed.
award passed. Award passed.
Only the
A copy of the award is enclosed. Award passed. Award
But,
has been passed.
Only thing is, my
The
lord.
money has not been deposited.
Yes.
No, if the money is not deposited, interest will accrue.
section 80.
Only the under 21, the amount, compensation amount has been determined here.
No. It's an award. It's an award passed. It's an award.
Last occasion, honorable. court
Land
asked for
acquisition
the
case,
better-
this is an
even
award
We were
pass.
not very sure.
Yes. 150 crores, this the total amount will be 153 crores, 4 lakhs, 12,652. This is the amount to be passed and the patadar is this positive so and so in connection with the acquisition of Iman as a reserve area. So we do one thing, we direct them to deposit it before the district court.
No, my lord, there is a point, my lord.
Mm.
If the lordship will kindly have the act. I don't think civil suit is maintainable. my lord.
No, not civil suit. It's a reference.
There is no
There
reference.
is no, that is the thing, there is no reference. here.
There is no reference.
No. As of now, you are entitled to the amount.
As of now, the patadar will get the money.
You are entitled, whoever it is, this
Yes.
Purbanchal, whatever.
Yes, I
name.
represent.
Yes, Purbanchal Griha Nirman Unnayan Committee.
Yes,
You will be entitled to this amount. There is no
Yes.
quarrel, there is no deposit in the court, nothing.
yes,
But if they file an application seeking apportionment,
yes.
then only it will go there.
Yes, yes,
This
that
is,
will be
I think that is the provision how it is to be there. The award has been passed, so
Yes,
now
yes,
they have to
absolutely.
go for that.
No, no. Only thing is, my lord, the, as per the provision.
Now the award has been passed in the month of August 2024. August, na?
76, my lord.
No. Award has been passed in the month of on 8/8.
Yes,
Oh no, award passed recently. After my order.
yes.
Isn't it? Madam? It's because of this order. I passed an order on 8/8,
Yes.
thereafter they passed the award.
But only what I was trying to make one submission, my lord.
Yes.
In none of the writ petition, there is any live issue pending. If you lordship would kindly go to the prayer portions in the writ petition for a moment, my lord. All the 3 writ petitions. For example, if your lordship will kindly take 4395 of 22.
Your petition is 7457.
My lord, mine was 745. There, my lord, that has become infructuous. My writ petition has become infructuous.
Now
Because
let us
when the
see,
prayer was.
let us see 4395.
Yes. Please come to the writ petition, my lord, page 22.
Read in the nature of mandamus,
Yes.
shall not be issued directing for de-reserve the land measuring.
That cannot happen.
That can't happen. Read and directing municipal to accord permission, that can't happen.
That cannot happen.
Allow the area to construct residential complex upon the land measuring
cannot
30
also happen.
meters. No. So these
So
are
kindly
the-
come to the other writ.
So acquisition has happened. This
Yes.
acquisition done under what provision?
Basic others, my lord, initially they invoke power of the Assam Act, but eventually it is under the perhaps 13 Act.
They did it under the 13 Act.
Initially, it was requisition was done under my lord 1964 Assam Act.
No, this is done under Act. A payment of compensation is made under the 13th.
Yes.
Yeah, because otherwise they will have
Yes,
a
yes.
lot of other
Yes,
complications.
yes.
So this is infructuous.
Yes.
No,
Lord,
because
kindly come to the next-
award having been passed, so
Yes.
they must have come up with a notification under section 6.
Yes,
Now the land rests upon the state.
state.
Section 6 notification was of 22nd December 23.
Section
Page
6,
number 353, my lord.
where? Of?
360.
Of- 360.
360 in Mike 6254, your lordship.
Yes,
6254.
6254, my lord.
Page?
Page, your lordship will find at 360, 360, affidavit
Huh.
by the respondent number 7.
360. Yes, it's fine. It is hereby notified that in pursuance of section 6(1) of the Assam Act, governor is pleased to decide acquisition with effect from the date of publication.
So
of-
the land now vests
Vests
as
in
on
the government.
22nd of December 2023.
Yes. Now, my lord will kindly come to the prayer in that writ petition, my lord. Page 27.
Yes.
It has been answered. Should not be issued, delay responded to issue notice of acquisition proceeding. So it has been done. Then below, for a moment, we'll kindly come to the last petition, 7355. Page 33. Issue notices of acquisition proceeding, it is done. And prayer number 2, my lord, a suit is pending, we say.
Respondent number 7 is you.
Yes.
And the suit has no relevance also.
No relevance. So virtually, my lord, in none of the writ petitions, any live issue is pending.
No, therefore,
Yes, but then nevertheless,
this will not be a reference in terms with that act of
Yes.
2013.
Yes.
No,
It is not on record.
this will be a reference in terms with section 12.
section 70.
No. There, because this acquisition is done under the 64A. So it will be
Earlier.
I'm
under
sorry.
section 12.
Some act of 64.
Oh, a land acquisition.
One second.
Section 11, I think.
One second.
Yeah, some land reconstruction.
12 member.
12, no? Some land acquisition.
Collectors shall in every case where any person aggrieved by an award under so and so makes an requiring matter reference to the court, where there is a disagreement with regard to the compensation payable under subsection 4 of section 11 on the application of person entitled to compensation requiring matter to be referred to court, refer the same to the decision of the court. Section 12.
This will be under section 12. Right?
12B, 12(1)(b). No, it's a reference.
So it will be under 12(1)(b).
Yes.
Then if we read this with Land Acquisition Act 1894, we have to read this with section 30 of the Land Acquisition Act 1894. But
But by this, it has been repealed by this act. The 30.
Mr. Vishwas, we don't expect such type of
No, no,
argument.
I'm saying it has to be read, but I think it should be
Plain
read with
definition.
this section, Your Worship. The present one.
See, why it is not required? Because it is a legislation by incorporation. Kindly see section 30(12)(2). By legislation by incorporation, they have incorporated this provision of Land Acquisition Act 1894 to this provision. Therefore, you have to read it with section 30. It is only in respect to the compensation, it is from 26 to 30 will apply.
1897.
1894 Land Acquisition.
1890. Yep. 1894.
No, because here, where the amount will be deposited is given here in this act. How? Because 30, if we read it, there are questions out here. Here you will see section 30. Yeah, 30. Yes. Dispute as to apportionment, where the amount of compensation has been settled under section 11. If any dispute arises to the apportionment of the same or any part thereof, or as the persons to whom the same or part thereof is payable, the collector may refer such dispute to the decision of the court. Then payment of compensation, how it is to be done. On making of an award under section 11, the collector shall tender the payment of compensation awarded to him to the persons interested entitled thereto according to the award, and pay it to it unless prevented by some one or more of the concept mentioned in the subsection. If there shall be no consent to receive it, or if there is no person competent to alienate, or if there is any dispute as to the title to receive the compensation, or as to the apportionment of it, the collector shall deposit the amount of the compensation in the court to which a reference under section 18 would apply. So this has to be done under read 30 with 31 too.
31 to there should be. Because the dispute exists.
But you have to raise dispute,
Yes, sir, we have
not
to.
in a writ proceeding. So we dispose of all the matters.
Yes, yes,
here
yes.
and- Where, in which writ petition I get the chronology?
I
of-
think Lordship can, 7457 is the first case.
In your case, all these notifications are there. In that, in your case,
Both the cases it
Lordships
is.
can take up this matter, my lord. I think Ismailur Tasaniki.
7355 may be taken up. I think that
That
context.
can be taken as the lead case.
7-3.
55 of 23.
No, I just need which are the notifications, how it started.
My lord, regarding acquisition other than that section 6, others are not on record. In fact, my lord, the relevant notices are at page 352, 353, and 355. I said I didn't have.
Got it, got it. Payment is to be made by whom?
Actually, the money will have to be deposited by the requiring department, that is Dohua Department of Housing and Urban. Okay.
There is an order of 355.
Department of Housing and Urban Affairs. The government will 355 city can table করে দেওয়া আছে।
Heard Mr. Kane Chaudhary, the learned senior counsel, assisted by Mr. R.J. Das, appearing on behalf of the writ petitioner in WPC number 7457 of the 2018. Mr. A. Biswas, the learned counsel, appearing on behalf of the writ petitioner in WPC number
6254, Your Worship.
6254
It is item number
2023. Who is appearing for 7355? And the other one 4395? Okay. Mr. A. Dhar appearing on behalf of the learned of the petitioner in WPC number 7355 of the 2023. Ms. So appears on behalf of the writ petitioner in WPC number 4395 of the 2022. On 1/4/1996, the Deputy Secretary to the Government of Assam Revenue Settlement, by its letter number RSS 708/95/20, had granted the settlement of a plot of land measuring 30 bighas covered by Dag number 602 of village Hengrabari under Beltola Moza in favor of the petitioner. Number one, in favor of the petitioner in WPC number 7457 of 2018. The said settlement was granted for construction, for building residential houses in organized way, subject to payment of 60% of the land value as premium. The Deputy Secretary, the Government of Assam, further, the Government of Assam, in the Revenue Department of the Government of Assam had also directed the Deputy Commissioner Kamrup to hand over the possession of the land to the petitioner in WPC number 7457 of 2018. In pursuance to the said letter dated 1/4/1996, the petitioner in WPC number 7457 of 2018, hereinafter for short referred to convenience referred to as the petitioner committee, had deposited the land premium amounting to rupees 27 lakhs by Treasury Salan dated 3/1/2000 and 7/4/2000. Pursuant to this, although there were certain objections raised, but the land possession of the land was handed over to the President and Secretary of the Petitioner Committee on 27/5/2005, and the land was accordingly mutated. On 17/7/2009, a periodic patta was issued in favor of the petitioner committee. Pursuant thereto, the petitioner committee entered into an agreement with one MS Empolisa Construction and Marketing Private Limited for carrying out the construction activities. Pursuant thereto, the petitioner committee had executed an agreement with the petitioner in WPC number 4395/2022 for construction of the multi-storied RCC building. আগতো এইটো নালাগে, and police নালাগে. In the year 2008, the Guwahati Water Bodies Preservation and Conservation Act 2008, hereinafter referred to as the Act of 2008, was enacted. And by Gazette notification dated 7/8/2008, the said act was brought into force. In the said act, the land of the petitioner, which was settled long back in the year 1996, and in respect of which the periodic patta was issued, was included in Schedule 3, Roman 3 of the said Act of 2008. This inclusion of the land belonging to the petitioner committee within the scope of the Act of 2008 is the subject matter of challenge in WPC number 7457/2018. Who are the other petitioners? Yes, who is Mr. Imdiwar? Who are you?
I have been allotted 6 bigha 1 kata 10 lakhs. We have been.
This is a different plot of land.
See, no, out of 30 bighas of land, 10 bighas of land were allotted to this, say 6 bigha 1 kata 10 lakhs was allotted to Ismailur Rahman and others. And this 3 bigha 10 lakhs was allotted to this Usa Dugad. And 20 bighas of the land of the Samiti was given to by the Samiti itself.
My lord, we dispute that position, my lord. We don't agree to that.
We have annexed the receipts, and we have annexed
It's
the
okay.
police certificate, everything.
And that is subject matter.
Wait. We can find it out from here, na? Patta is, how much is the area? Basti, man, how much is the
30
land?
bighas, 30.
My lord,
This
what had
is
happened?
Mati Puriman 801.30 R. Let me find out.
Page 40 of my.
No, his periodic patta is of 30 bighas.
Yes. Kindly come to page 101.
No, page 53
Yes,
of your repetition. It
Yes.
is 401.40,
Yes,
which
yes.
is equal to 30 bighas.
uh,
Then here's a periodic patta.
Here's a period.
then.
And we have been allotted from, we being the
My lord,
society
there was a
members.
committee, they did some mischief, my lord. Subsequent committee has, my lord, revoked all these decisions. That's why we.
No,
said
but
that-
the patta remained as it
Yes,
is.
yes,
Patta
yes. I'm
remains
the
the-
landowner.
Then how did you
We have some registered deed of.
Huh?
We have a registered deed with,
From?
Registered deed from the Samiti.
they sold it to you?
Yes. Against the
they have
PPO,
allotted
the
this.
allotted-
No,
The
you-
workshop will
No,
come.
they have sold it to you by sale deeds.
No, they have Even declaration, by way of declaration.
Anyways, let us, let you, let
These are
this be
dispute
thought
before
out
the
there.
trial.
Okay.
They have handed over position also, and we have entered into.
Their
এই
own
ওপৰত যে
certificates.
দিছো এই পাত্তা ইছ্যু কৰিছে বুলি এইখিনি লেখক এই তাতে এটা লাইনটো লিখি দিম হা পাত্তা was issued in favor of the petitioner committee on 17/7/2009 bearing patta number 1370 and the concerned DAG number was 602/1074 old and 3785 new. Also, it is pertinent to mention that the patta specifically mentioned 401.40 hours of land, which corresponds to 30 bighas of land. Also, petition icon file. The petitioners in WPC number 7355/2023 and WPC number 6254/2023 also claimed rights over the said land on the basis of certain documents executed by members of the petitioners committee.
President and secretary.
However, those documents are not deeds of conveyance. However, admittedly, those documents are not deeds of conveyance or sale. The petitioner in WPC number 4395/2022 has filed a writ petition challenging you have a avenue out there, otherwise I would have dismissed all your petitions. The non-granting of the challenging the inclusion of the land which was settled with the petitioners committee within the ambit of the Act of 2008, as well as also seeking direction upon the GMC authorities to allow the said petitioner to construct, to grant permission to the said petitioner to construct the houses as per the approved plan. While these petitions have been pending, the government took a decision to acquire the land. And accordingly, a proceedings was initiated under the Assam Land Requisition and Acquisition Act 1964. For short, the Act of 1964. In pursuance to that, on
22nd of December.
the said land acquisition case was registered and numbered as LA case number 35/2023. It is seen that on 28/12/2023 and on 22/12/2023, the notification under section 6(1) of the Act of 1964 was issued, which was published in the Assam Gazette on 28/12/2023. At this stage, if this court duly takes note of section 6 of the Act of 1964, it would be seen that section 6(2) of the Act of 1964, it would be seen that upon issuance of the said notice, which is published in the official gazette, the land vests absolutely in the state government, free from all encumbrances. Full stop. Under such circumstances, with effect from 28/12/2023, the land vested upon the state government. Full stop. Under such circumstances, the reliefs which have been sought for in WBC number 6254/2023, WBC number 7355/2023, and WBC number 4395/2023 had become redundant. Be that as it may, taking into account that during the pendency of the writ petitions, these developments had taken place, the various orders passed in the instant proceedings showed that this court have from time to time inquired with the respondent authorities as to what was the stage of the acquisition proceedings. Today, Ms. M. Burman, the learned counsel appearing on behalf of the district administration of Kamrup Metropolitan District, have submitted before this court that the award in land acquisition case number 35/2023 have already been passed in the month of August 2024. 5/9 have already been passed on 5/9/2024. Full stop. A copy of the said award in Form Acts have been placed before this court. Full stop. A perusal of the statement it has also been informed that the said award have been duly filed in terms with the Act of 1964 read along with the Land Acquisition Act of 1894. Under such circumstances, the said award had attained finality and becomes a conclusive evidence between the district administration, that is the collector, and the persons interested. It is further seen from the said documents placed that the total amount to which the petitioner committee has been shown to be entitled to have been calculated on the basis of the right to fair compensation. What is that name? It's a long name, no?
Yes.
Right to?
Right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Act 2013.
For short, the Act of 2013, and more particularly, sections 26 to 30 of the said Act. The total amount payable to the petitioner committee has been shown at rupees 153 crores 4,12,672. Full stop. The said document, along with the award which have been placed before this court, is collectively kept on record and marked with the letter X. Full stop. This court duly inquired with the learned counsel appearing on behalf of the district administration as to whether the amount has been deposited to the district commissioner for onward dispersal. The learned counsel submitted that the request had been made to the requiring department, and the same would be done so. Requiring department, that is the Department of Housing and Urban Affairs. And the same would likely to be done so at the earliest. Taking into account that the award have already been passed and the land now vests upon the state. The petitioner submittee herein would be entitled to the said amount, subject, however, entitled to the said amount. Be it as it may, it is also seen from a perusal of section 12(1)(b) of the Act of 1964 that any person aggrieved as regards the aggrieved as regard to the apportionment of the compensation can very well approach the collector by seeking a reference to the court. It is also seen that when such an application is filed before the collector has to refer it to the court, that is that court, and in the instant case, it would be the court of the district judge, Kamrup Metro. It is also seen in terms with subsection 2 of section 12 of the Act of 1964 that by way of legislation by incorporation, the provisions of the Land Acquisition Act 1894 have been incorporated. Under such circumstances, if an application is being filed expressing disagreement in respect to the apportionment of the amount, then in such case, the collector, that will be the district commissioner, Kamrup Metro, has to act in terms with section 30, read with section 31(2) of the Land Acquisition Act 1894. However, the same has to be done. However, the same is only to be applied subject to a dispute being raised. Mr. Ed Biswas and Mr. Edhar, the learned counsels appearing on behalf of the petitioners in WPC number 7355/2023 and WPC number 6254/2023 submits that they would forthwith take appropriate steps in that regard. 15 days time is given for filing the appropriate application before the collector. With the above observation, this court, accordingly, this court disposes of the incident with petition, thereby granting liberty to the parties herein to further proceed in accordance with the provisions of law. Before parting with the record, this court, however, makes it clear, finds it relevant to observe that the delay in disbursing the amount by the requiring authority would only lead to enhancement of the compensation amount in terms with the provisions on account of interest, which is required, have to be now paid from the coffers of the public, from the public exchequer. And as such, this court observes that the concerned respondent authorities, and more particularly the requiring department, shall take appropriate steps, keeping in mind that delay in disposal, delay in this, delay in depositing the amount to the acquiring authority, that is the district commissioner, Kamrup, as well as the district commissioner delaying in disbursement of the amount or placing it before the court, as the case may be, would entail huge expenditures on account of interest.
Interim orders passed in the proceedings.
All interim orders then no longer exist.
Obliged.
Deeply.
I say so. এখন ভয় দিব দেই, এইখন কোর্ট এখন এৱাৰ্ডখন আছে। The parties would be at liberty to take copies of the awards if they
Yes.
would be, the parties herein are given the liberty to apply before the registry of this court for certified copy of the decision done. Now, when you are paying that, 4,25,000.
4,25,000. They asked for the fund demand, Lordship. From the
When?
fund demand has to come from the executive engineer, Dhubri division.
The
Thereafter,
payment will be made when?
that will take the decision when can payment can be made, Your Lordship.
Why?
Because right now, to be very frank and honest, Your Lordship, there's positive fund in department, Lordship. That's why.
Why? PhD department has no money?
To be honest, it's
Hello? Let's see the head of the account of the petition of the, PhD department. And see. Money is not there. How is it possible? Get the money from somewhere?
I'll take the instruction.
Because this is not a writ,
Yes, sir, exactly.
it's a content.
True.
You can't delay this. Writ is okay, but this is the contempt. Cannot. Don't have money means nothing. Sell your, the office is there now. Somewhere. You want to take that office? Take that office. Take that office. It's in Norkahood Hill. It's a good office, PhD. Give it to them.
I'll take the instruction, Lordship.
Sell it. We'll put it to auction sale. Sell it. Nothing doing. This is the contempt matter.
Yes, exactly.
Before vacations. Let him have also some smile before the vacations.
Right.
Didn't it?
I'll get the instruction, Lordship.
They don't come up with this thing that they don't have money. Work is done, payment is to be made.
Yes, Your Lordship.
And this was shown
is
as,
not the ground, Your Lordship.
this was shown a long time back. You can't say about the demands. I'm not concerned with this demand and all. We have been concerned in the writ. This is nothing to this. This is the same document which he enclosed at the, in the
Yes, sir.
time of writ petition. And the writ petition was filed when? 2022.
Right.
And this is the document of long time. 2020.
Right.
I don't know, have you all these things. Find out what are the other things which can be sold. PhD, does the commissioner have any vehicle?
Okay, I'll get the instruction. This
Vehicle,
last time-
vehicle?
Here's a vehicle, Lordship, but I'll get the instruction what can be done for making the payment.
Before vacation, pay, else if the commissioner has a Tata, the Innova card, that will also fetch. You won't mind taking the Innova, the commissioner or secretary of the Innova. So 15 lakhs, 14 lakhs, you'll get it. Maybe second hand 4 lakhs, 25,000. You can sell it, huh?
It's not big amount, my lord, only.
Understood. Therefore, you take that vehicle, sell it. I'll give you the vehicle. Give you the vehicle number. We'll ask them to transfer it to you.
Okay, last time we got, I'll take the instruction, Lordship.
Okay.
Anything-
Mr. R. Gogoi, appearing on behalf of the respondent, submits that that the process for payment of the amount to which the petitioner is entitled to is being taken up by the respondent authorities, by the respondent herein. And he would therefore request for some time. It's the matter again on 25th of September at 2 p.m.
Nothing left.
25th of September, 2 p.m. I'm not putting it in the order. It may not look nice. Otherwise, get the vehicle number of that day. I'll ask them to transfer it. Vehicle will do
All right.
of the commissioner and secretary.
Please.
Item 11,
This matter was taken for instructions. This matter was taken for instructions by my
Lordship.
For what instruction?
What has happened to that appeal by which, due to which needs non-consideration, we are before the court, my lord.
What appeal?
My lord, we are seeking cancellation of mutation. Appeal has been preferred.
Oh, that one.
Yes.
Oh, that is why now I see it's a very fat file. Okay. I said about economy, what? And well, you are from the forest department.
No, I'm the petitioner here.
No, no, otherwise,
No, I'm
You
not
are-
connected. That side I'm not connected. This is.
understood, but you are the forest department. Don't you see so much of environment degradation in putting a petition of such a fat magnitude? Huh? What has happened?
He was looking after my lord, but his mother is sick, so he asked me to appeal.
Lordship, these 10 numbers of appeal, Lordship, only the first page of that appeal were submitted before the deputy commissioner.
It's okay. So then we can pass an order to the fact that you have the other copies, no? The first page is there. So
Only
obviously
first
these
page.
were filed within time. So otherwise, let them file another copy
And
and
thereafter,
then you
Lordship,
decide it.
thereafter, Lordship, because of this, the next page, Lordship, not the bunch, not that stapled one, Lord. Yes, Lordship. This is a letter from the circle officer to the additional deputy commissioner revenue. As because it was sent to the circle officer because of that.
Appeal has been filed. What is this circle officer
Lordship,
going
that
to
is
do?
why, as because most probably because of the
This
first
is not
page,
done, no?
it is to be done. by
That
the
day,
deputy-
and once that the circle officer does not do anything, what are you going to do?
Lordship.
You, the district administration as well as the revenue will come up and say, which happened in the earlier matter, in another matter which I took it up on last Thursday. They say, what is this? The filing of an appeal, the matter once the mutation order has been passed by the circle officer, an appeal only lies. How can it be done? Was that not the submission on that day by Mr. Arbor Pujari?
30 over there, 147 to 30 over there, 150.
You cannot do all this miscale business out there. If you don't have the copy, I will ask them to file it properly, and the limitation will be taken as is on 4th of year, and you proceed.
Lordship.
Well,
I think that is a fair.
Yes, Lordship.
it ends, takes care of the.
Yesterday, Mr. Gogoi, you were submitting that ST certificate. na?
Yes, ma'am.
So I was getting through that because I knew about that law pertaining to it. But yesterday I got that very paragraph. You find it in paragraph number 118 in the recent judgment, 7 judges judgment in Davinder Singh versus State of Punjab, of the opinion of Justice Chandrasur. Paragraph 118. It's reported in 2024 SCC Online 1860. It's a very big judgment. It is around 700 pages. It's a different thing. But that is the paragraph. 118 is exactly on the point as to how means whenever you are given when what you call a constitutional order is being made under under 50, then it is only in respect to that area mentioned in the schedule, not otherwise. there it was, they were dealing with the question in Andhra Pradesh, there were two tribes which were only given for two districts. So it said only in these two districts, outside they would not. I've incorporated that paragraph out there in that order, although that day I didn't do it. Yes. We dispose it of thereby giving you, and the appeal shall be construed to have been filed on so and so.
Right.
And this miscase business, I'm not going to
Lots,
consider all this.
lots.
And you cannot transfer.
No, but
being
most
filed
probably
on-
because of that first page, the other parts were not there because of that
That is why you lost it.
lots it.
In fact, it also happens in our, that day I was taking up a matter pertaining to proceedings filed under 190 and 200 before the judicial magistrate. What he did, he transferred the entire file to the police station under 156(3). Now he doesn't have any file. This is the same thing which has happened. You must have filed the appeal, they send it to the circle officer, let the circle officer decide. So no files. Shall-
In this case, Lordship, the mutation order was passed on 25/4/2019. And the appeal was preferred and it was received in the office on 4th of May 2021.
Whatever may be, you decide.
Lordship,
On the question of limitation, whatever may be, there might be many other cases also. Why
Right.
they have? That is your lookout.
Lordship,
If they have to explain, they will explain the delay. This is an appeal file under 147B.
the appeal is
Mr.
preferred under section 53 to
53A2.
Huh?
53A2.
53A2, no, it's an against the mutation order.
It's against a mutation order, man. Mutation order, man.
Mutation order, how are you doing it under 53A2? It will be under 147.
I still corrected them. Application for first developed by that.
Therefore, he must have sent it to them.
Lordship, that is right.
But whatever may be, the circle officer has no business on the 53A. It is only the deputy commissioner who can do so. Or the settlement officer during the settlement operation. Anyways. Therefore, heard Mr. D. Gogoi, the learned counsel, appearing on behalf of the petitioner. Mr. H. Sharma, the learned government advocate, appears on behalf of the respondent number 3, 4, and 5. Yes, sir. The petition, the instant petition has been filed. Being aggrieved by the inaction on the part of the District Commissioner Borpeta in not deciding the, how many appeals were there?
10 appeals.
10.
10 appeals.
10 appeals which were filed by the petitioners on 4/5/2021, challenging the mutation orders in respect of a plot of land measuring 18 bighas, 4 katha, 10 lechas covered by Miyadik Heras Patta number 108 of Dag number, covered by Dag number 137 and 179 of and included in Miyadik Heras Patta number 108, situated at village Bonakuchi, Moza, Borpeta, in the district of Borpeta, Assam. This court, by an order dated 16/8/2024, issued notice and directed the state respondents to apprise this court as to whether the appeals have been duly received by the officer of the District Commissioner, Borpeta, and if so, what is the present status of the appeals? Full stop. On 22/8/2024, Mr. H. Sharma, the learned counsel appearing on behalf of the district administration, submitted that based on the file number which was provided by the petitioner, the statutory appeals could not be located. However, in view of the additional affidavit filed by the petitioner, and there being another file number being BRKG-43/2020/307, he would take instruction in that regard. Today, Mr. I. Sharma submitted that upon inquiry being made, it came into light that there was a pleader's notice issued by the advocate on behalf of the petitioner. On account of the inaction on the part of the responding district commissioner in deciding the appeals, 10 appeals. In the said pleader's notice, there was reference to 10 appeals, of which the first page of the said appeals were also enclosed. The learned counsel appearing on behalf of the district administration submitted that in view of the said document, first page of the appeals, it is seen that 10 appeals were filed by the petitioner and were received by the office of the deputy commissioner on 4th of May 2021. However, they do not have the records of the said appeals. In addition to that, the learned counsel appearing on behalf of the district administration submitted that on further inquiry, it came to light that a miscase had been initiated bearing miscase number 17/2024-25 on the basis of the pleader's notice, which was issued, and notices have been generated.
Fixing the date on 25/9/2020. Date of release.
This court have duly taken note of that the appeals were filed before the district commissioner.
One of that appeal is at page 247.
Borpeta, in terms with challenging the mutation orders. Although the appeals have been shown to have been filed under section 53A of the Assam Land and Revenue Regulation 86, but Mr. D. Gogoi, appearing on behalf of the petitioner, submits that these appeals are actually in terms with section 147B. B, you don't have that book in your submitting. You don't file affidavit, you don't have books. God may only save you.
Sir, this landlord area is totally new to me.
No.
First attempt.
Objecting anybody of any settlement forest law, you are
And
there
this-
to object and
that
then you
Arbor
have
was-
all the laws. Huh?
Arbor was taking care of this, his mother got sick, so the assistant to
Huh?
that Arbor was appearing, he was taking care of this. When his mother got sick, I had to appear.
Mr. D. Gogoi, the learned counsel appearing on behalf of the petitioner, submits that although in the appeals appeal it has been shown to have been filed under section 53A of the Assam Land and Revenue Regulation 1886, but the said appeals ought to be construed to be an appeal under section 147B of the Assam Land and Revenue Regulation 1886. The learned counsel for petitioners submitted their wrong quoting of the section could not divest the jurisdiction which is otherwise vested by law. Taking into account the above submissions and the fact that the appeals were duly filed on 4th of May 2021, this court is of the opinion that it is the district commissioner who has to decide, the district commissioner or the additional district commissioner who has to decide the said appeals. This court have also taken note of that upon filing of the appeals, the matter was referred to the circle officer and on the basis of which a miscase number 17/2024-25 was initiated by the circle officer. The same is totally non-est in law, inasmuch as the Assam Land and Revenue Regulation 1886 do not confer a power of review upon the said official, upon the circle officer. Accordingly, this court therefore, this court also takes note of that they find that the district administration, that the district office of the district commissioner, Borpeta, have misplaced the appeal memos.
The appeal memos were not misplaced. They have placed only first page of the appeal.
No, they have filed it.
No, Lordship, only the first page.
No, that is in the pleader's notice. They have only given the first page.
That is in the file, nothing more.
No, they would not. Why will they do it?
Lordship, this is the bunch which was sent to me.
Oh, that
Apart
is
from
it.
that-
That is along with the pleader's notice, they only give the first page.
Yes, the other part,
Pleader's notice was given recently.
no, Lordship, which.
With reference to the, I'm enclosing here with 10 numbers of pleader's notice received from so and so. Advocate along with so and so remand, you are requested to inquire. This is being written by the additional AR on 21.
To the circle officer.
Yes. So this is the pleader's notice which has been given to the circle officer.
And only the first page of the 10 appeals were submitted by them.
Why will they give this? Nobody will give
I
this.
do not know, Lordship, that is the thing that
No.
I have been told like that, and this is there only in the files. The other pages
These were
not
all
there,
DA put up on 6/5. Now tell me,
Lordship.
if this is the first page,
Yes,
at page number 3, all these pages.
yes, Lordship.
where-
All are
Then
6/5.
why will the dealing assistant put up on 6/5? One page? How can this be? It can't be there. The appeal memos were filed. However, later on, pleader's notice must have been given, because otherwise, why will the dealing assistant put up on so and so?
That is why it was sent to the circle officer. The rest pages were not there, Lordship. I have been told like that. That is the instruction I have received, Lordship.
Whatever may be, that must be wrong. Anyways. Last line too.
By skipping that part, Lordship, let them file a fresh one, Lordship, under the officer.
District commissioner have misplaced the appeal memos. Under such circumstances, there would be a requirement of reconstruction of the appeal memos. Accordingly, this court therefore disposes of the instant petition, thereby giving liberty to the petitioners within 10 days from today to submit fresh memo of appeals against the mutation orders, which were the subject matter of challenge in the appeals which were filed earlier. Upon filing of the said appeals within the period of 10 or 15 days mentioned herein above, the same shall be construed to have been filed by the office of the district commissioner for PETA on 4/5/2021.
6/5, that was received on
Not 6/5, no 6/5, 4/5.
4/5. It was received the
4/5.
seal lots. Oh, yes, yes, 4/5, 4/5.
The district commissioner shall thereupon decide the said appeals, taking it as appeals. The district commissioner or the additional district commissioner, as the case may be, shall decide those appeals as appeals filed under section 147B of the Assam Land and Revenue Regulations, and the same be done within a period of 6 months, within at the earliest, and preferably within a period of 6 months after service of notice upon the respondent.
May I tell Lordship that that misplaced part can be
Misplaced.
that misplaced, but
Then find it out.
that is not my instruction, Lordship, only a
That is my opinion,
Lordship, in that case,
not
Lordship,
your opinion. You have not submitted
Lordship,
misplaced.
what's the pleasure? All right.
Parliamentary item 27.
Lordship, during this matter, Lordship, the respondent number 225 has filed their affidavit in opposition. Lordship.
Oh, they filed.
Lordship, I want to file a reply, Lordship, so sometime may be granted. Lordship.
This is under what provision?
148 income tax.
A.
A.
Notice was issued, they took very for time. It was rejected because the time bar. So 148.
You have issued notice under 148A. So 148A, so you made the inquiry
Yes, sir.
under 148A. A. Then 148AB, you issued the notice.
Yes, sir.
148AB, you have issued the notice. Did he reply?
They file application seeking time.
Then
Then that was not considered because assessment, the time limitation was there up to 31st. Notice was issued on 15/3. They file application on 25/3, seeking time.
and then you therefore you pass the order on under 148A 88B.
No.
And this order under 148AD is being put to challenge here.
Not,
Isn't it?
not.
On the ground of
Lordship, I do not have Lordship, excess of 50 lakhs, Lordship, which was the requirement under 149, Lordship.
Huh?
If the assessment year process a limitation of 3 years, Lordship. And Lordship, that they're replying now that it was time, but Lordship, there is no such thing. Since Lordship, they have already started the assessment on 15/3, and there is an outer limit of 30 days. So my adjournment petition was filed within time, but they did not consider. So Lordship, there is violation of my principle of natural justice, Lordship. And they issued the order on 31/3.
no, we set aside that order of 41A 148AD and giving you the liberty and thereby enlarging the period that period from the date of the notice till today be excluded.
Lordship, let me find a reply, Lordship.
What is there to file a reply? That is all.
Lordship, because
What am I going to decide?
Lordship, I'll have to file.
Raise all these issues there.
No,
All the
Lordship.
issues there. You reply. There is a modus given out
I
there.
have already replied, Lordship.
Where?
It is there, Lordship. And if-
We have submitted the reply there.
It is there in the writ petition, Lordship. And they are saying that it is under their consideration, but they have not passed any order.
What?
Page 27.
148 notice is being issued.
Yes, Lordship,
Notice
page
under 148 is issued.
Yes, Lordship, 36, page 36 is my reply, Lordship.
Request for adjournment of the submission to the notice 148 is submitted. So and so
36 is
department
the-
issued a notice. Kindly submit online response in case no notice by logging in so and so. Now this is a notice under 148.
Annexure 1.
Order passed on the Iman. Then. In the case of the withdrawal notice. Now, what is this document? This document at page 36 of the writ petition.
Lordship, this is my reply.
This is your reply.
Yes, Lordship.
When did you give it?
This was on Lordship 17th of August 2022.
Now, this is dated 20th of May 2022.
748. Deal.
Huh?
It was
This
Yes.
is for 20, this is against 148,
yes, Lordship.
not 148 AB.
Yes, Lordship. A,
18.
Lordship.
Huh?
18.
No, this is not against 148 AB.
D.
This is against 148.
148 AD.
No.
40.
Page 36 is not 148. It is against 148, not
What?
148 AB.
It is under 148A, Lordship.
Huh?
148A, Lordship.
No.
Lordship.
How is it possible? The order was passed on 31st of
31st of
March 2022. So therefore, this document at page 36 on top shows acknowledgement date 25
May.
2022.
Yes.
So 25/22, if it is being received, it is after the order being passed on the 148 AD.
Yes, Lordship.
So this is a notice. This is a reply in pursuance to 148,
Yes, Lordship.
because 148 was issued then.
Yes,
When?
Lordship. 148A on 15th of Lordship March.
148 was issued on when 31. This was issued on 31/3.
No, Lordship, 148A notice, Lordship, at page 24, Lordship.
Understood? That was issued.
Yes, Lordship.
148 was issued on this. Nah.
Yes, Lordship.
148 was issued on 15th,
Yes, Lordship.
15/3.
And the order was passed on
And
31
the order was passed on 33.
31/3.
31/3, and then they issued that notice on the 148A.
Yes.
for this, not no 148
Yes, Lord.
on 31(3).
Yes, Lord.
So you did not reply. You did not reply to the 148A(B) notice. This is the 148A(B) notice, page 24.
Lordship.
You file only a adjournment petition.
Huh? You file only an adjournment petition on 25(3).
Yes,
Then they said that the time is going out.
but Lordship, there is no time of limitation, Lordship, no bar, Lordship, because they have already initiated the. So what was the hurry, Lordship, for them to pass this order, Lordship? So Lordship, let me file my reply, Lordship, because anyway, Lordship, there was a limitation, Lordship, of 3 years, Lordship, because I do not have that amount with me, Lordship, on the assessment year 2015-16, and which I have taken from the bank and Lordship in my adjournment petition, Lordship.
Let us see the notice within how much it is to be given.
Lordship, 148 D.
This is for the period, which one?
Lordship, 15-16.
Huh?
15-16. Assessment year 15-16.
15-16.
Yes, Lordship.
15-16. What is the period of limitation?
Lordship, 149, Lordship. It is 3 years, Lordship. But Lordship, it can extend to 10 years if Lordship, it is found that the amount is
If
in
the
excess of
period,
50 lakhs.
no notice under 148 shall be issued for the relevant assessment year. If 3 years have elapsed from the end of the relevant assessment year unless the case falls under B. If 3 years but not less than 10 years have elapsed from the end of the relevant unless the assessor has in his possession books of accounts or documents or AR which reveal that the income charges were represented in the form of assets which have escaped assessment amounts to or is likely to amount to rupees 50 lakhs or more. So it will be within the period? Because you are asking for some 78 lakhs?
Yes, Lordship, but I have replied, Lordship, that those time deposits were never done and the bank also certified, Lordship, at page, Lordship.
Understood, you replied later, na?
But Lordship, in my adjournment petition, Lordship,
Wait. Information received from the inside portal, deposit in cash.
it is in page 25, Lordship.
The information as stated above in the possession of the has been duly flagged in accordance with the risk management. As per the amended provision of Iman, under Iman shall not be issued unless there is an information with the assessing officer and the necessary conditions laid down for issuance of 148 is satisfied if the assessing officer is in possession of information which suggests that the income chargeable to tax has escaped assessment amounting to as per annexure Iman and the said amount information is duly flagged in accordance with the risk management. The income chargeable applicable of the Iman are hereby given an opportunity to explain about the understand why notice under section 148 will be given. Now, how much has escaped assessment?
According to them, Lordship, it is around for 78 lakhs.
It can be.
Yes, Lordship, they have stated, Lordship, in the order, Lordship.
No, in the order it's okay. Where is the order?
Lordship, at page 32, Lordship. In the case, income has page 32, Lordship, second last paragraph.
Account number so and so. As per the verified data, we are the SSC did not file a return of income for assessment. Since the SSC did not file the return of income for the assessment year, the income corresponding to the amount of rupees so and so, as per details in the table above, is required to be assessed. Hence of Iman. Entire injection, etc. SSC return. This key in this Now, on one hand, you are categorically saying that you did not give him time on the basis that the period will be over on 31/3,
2000.
meaning thereby, otherwise it was 3 years, 2015-16, it will be 3 years will be completed when?
19 Lordship, 19.
19?
31/3/2019 Lordship.
19.
Yes, Lordship.
Then why you are saying that 22?
Because even if Lordship, it goes to 10 years, it can go to 25 Lordship.
He is taking the benefit of that act. Then isn't it an admission on their part that it is the second proviso does not apply?
Yes.
B does not apply if they are asking for it. How, why are you saying that on 31/3/2022 it will end?
Page 48. Page 48 Lordship of their application, which was filed on.
That I have looked into. So if that is the ground, so they are therefore applying B. If B is there, it is 10 years. But how, if it is A, then isn't, if it is, they are admitting it under 31/3 because they are asking for extension because of the COVID. So the COVID period is exempted from 15/3 to 2020 to 28 to 2022 and 28 to 2022, 21, 22.
22.
22, plus there another 90 days
90.
per year. For assessment also, how much? What is your basis to calculate it on 15th, 31?
That is not been clarified. That point has not been dealt with.
That is the answer. Because that if you are saying that, then it is, you are calculating on 3 years. And 3 years would it be over if it is 15-16? If it is over, then obviously if it is over, it would be, when it would be over? It would be over on 31st of March 2019. So obviously it is over. Then the period of limitation goes. Now if it is not over, then you are applying B. It is still under time. And then why you couldn't give him another 15 days?
If there is a notification, but they have not brought that. Because with respect to direct taxes, there was a notification with respect to COVID period.
Huh?
Yeah,
Well, I'm giving you the best of the thing.
Lordship, I
Let it be a COVID period. I give you as per Supreme Court judgment also, if you give it, but then also, how do you end it? If you end it, if you are calculating at 3 years, when it will end for 15-16? The 15-16 because the financial year is 14-15.
Yes, sir.
The assessment year is what?
15/16.
Date of the order, no, assessment year is 15-16.
15.
Financial year will be 14-15.
14.
So financial year 15-16, in the last of the year will be 19. 31/3/19.
It's 90.
19. 31/3/19, you don't get the benefit of COVID. You can't. COVID has not come. It was not even in Wuhan. So understand you don't get the benefit of COVID. So thereafter you come in, let us assume then 3 years is over. Now after that, if you want to bring in the 50 lakh aspect and make it 10 years, why wouldn't you give it for another sometime? Can that be the ground that is ending? There is no explanation to that proper. Because you see, or if we are to take your justification, then anybody can issue a notice 1 day prior. It has to be a reasonable notice.
Yes, sir.
Can you ask me tomorrow, look here, your escape assessment has happened. I am giving you this notice. Period is ending on 31/3. So I am giving you only 2 days notice. Reply. Or 1 day. So that I can pass an order, then I initiate the reassessment proceedings under 148.
Your Lordship, notice was issued on 15/3.
Eh?
Here in this case, notice was issued on 15/3.
He asked for time on 25/3.
25/3.
And 25/3, you said nothing doing because of the fact you have not come up with this. He later on submitted against the 148 he gave, but against the 148 you don't reply. What you have to file your return in, then the drive shots judgment kicks in. Answer from you.
That point has not been answered in.
Huh?
Affidavit also, this point has not been.
Yes, Mr. Upamanu, why you are filing affidavit? Tell me.
Lordship, I want to file a counter, Lordship brings.
Why?
Lordship, because they are also claiming Lordship, a plea of Lordship alternate remedy, Lordship. To that also I want to.
Forget about the alternative remedy. If it is on the limitation ground,
Yes, Lordship.
that goes.
Yes, Lordship, it goes.
You forget about alternative. But if you may file it, you want to go any other court, it's okay.
No, Lordship.
They may go into the question of remedy. I don't go into these alternative remedies unless it is absolutely necessary. Here is the case, therefore, if he says he is outside, then obviously 1923 years will be on 31st. So he can't issue that. COVID did not kick in. After that, unless he shows some notification. And secondly, if it is the other one, let us assume maybe 10%. So 10 is till 2025. So if that be so, what stopped him from only giving him so in such a hurry? So we set aside this and can have that.
Lordship,
Okay.
if Lordship,
While 2 weeks.
Lordship, if Lordship is setting aside and quashing this notices, Lordship, I do not have it.
No. There is a question out there. I main question. There are 2 ways.
Yes, Lordship.
First is I may quash it on the ground that it is beyond limitation.
Yes, Lordship.
Matter finish.
Yes, Lordship. And
The
then-
second is whether they can at all do it, taking into account, means otherwise wouldn't it be unreasonable? You come up one fine morning, I'm issuing a notice, you file it within 10 days or 15 days, you file a reply because our period is ending. But if that be so, if B applies, then you are 10 years, what is the justification not giving you another 10 days?
Yes.
And therefore I can set aside that and giving you that this particular reply which you have given shall be construed to be a reply under 143 A, B, C, and then to decide again. That's it.
I'd like to file a reply. Short reply. Lordship.
What?
A reply, Lordship. I'd like to file a reply to the affidavit.
Hello. Have it. You just get your instruction. We'll have it next week. It's a small matter. We finish it up. We'll have it on 19th at 2 p.m.
Yes.
Just get this specific instruction.
Yes, sir.
Whether there was anything, and if it is done on this basis,
Yes.
it's a small point.
Yes, sir.
And whether he flies or not, it is the here. He wants to spoil his case. I don't know
No.
why. When the court is in your favor, kindly don't take time. I hope your senior must have explained to you. This the matter upon being heard, this matter again on 19/9/2024 at 2 p.m.
Highly applies.
Interim order passed the year shall continue.
Item 12 to 22.
You get your, I asked you to get the records also.
Yes, Lordship.
Record is there.
Okay, just
Only
keep the
notice.
records.
Notices are there.
Huh?
Order sheet and notice.
So therefore you ask them, how is it possible? Because if it is 15/16,
If it is beyond 50 lakhs, then
then it is goes beyond limitation.
Okay.
And then if they are implying, then why not?
I
Then
thought,
you take note of this and
Yes.
then decide.
yes, sir.
Yes. What is this? 2013-14 matter.
The morning I made a request for adjournment.
Why?
The same issues are pending before Honorable Supreme Court.
So what?
But kindly, I have,
What is the matter about?
matter, my lord, All India issues some debate note for a retrospective period.
Huh?
was
With the
ready to-
purchasers of coal from respondent
My lord,
number
come to
one, which is
pace.
a subsidiary of the correspondent, files the residual challenging the action of the respondent number one, issuing the impugned letters and debiting money in the account of the petitioners for a respective period from so and so pursuant to a communication which is here. And therefore, it has been further conveyed that the charges collected by the court.
My lord, come to page 31, my lord.
How is it relevant? These type of orders, how is it relevant?
These issues are pending in numbers of high court in India.
So what? Somebody has disposed of?
The lordship, one matter was disposed of by before the Calcutta High Court
In whose favor?
in petitioner's favors.
Okay.
Then Coal India filed a leave petition before the Honorable Supreme Court, and the same was tagged along with all the cases. CA number 107 1075418. I have
Where? What is this?
in number of cases, Coal India has filed transfer petition, but in this case, they have not.
You're not filing transfer petitions.
transfer petition.
Since the cases are pending here, so we did not take step.
Huh?
Since the cases are pending here, we did not take steps, but we are ready. If you like to,
You're ready to do.
if you like to permit, then we can.
Okay, let us hear you. You won't hear the petitioner. You
Ready
file
to-
a writ appeal on that ground that petitioner counsel has not been heard. File a writ appeal, take that ground. Nowadays, some lawyers take such grounds. Take those grounds.
That is not the intention. Since the cases are pending there, so we are waiting. actually.
Where?
Since the
Pending
cases
the
are
apex court.
pending in a Supreme Court, so we are waiting. That's the difficulty on our part.
Now, in your, you make e-auction on the basis of certain guidelines.
I have annexed the
Now, in the guidelines, whether this royalty and stowing charges were there,
Those three complaints were not there, but here your lordship can have a look at page 24. There, with all the statutory deals.
huh? So it says all other statutory. So these are statutory. Where page, section, clause?
At page 23 and page 24 also.
Before. Bidding process.
Bidding process, your lordship.
The coal should be value to be deposited in advance by RIAS shall be computed before along with the so and so man. EMD amount shall not be treated as an adjustment towards here. The above security deposit converts to here will be adjusted from the coal in here. In supply, in the case of wholesaler, once the coal is deposited by way of demand draft, so and so. Then, where is that?
At page 23, clause number 4.4, your lordship.
23.
Yes.
Yes, bidding. Are entitled to bid for the demand. Where is it? Here, the buyer while bidding shall quote the bid price per ton in Indian rupee as base coal price for FOA, exclusive of charges like statutory levies. So now you say therefore, it is already there.
And last person, your lordship.
These
And-
charges are as well as paid shall be payable,
And any
shall
other
be
charges.
on the buyer's account.
Yes, and any other charges as will be applicable at the time of delivery. When the coal is delivered, then all the.
So you raise the amount at the time of delivery. So this is it. It's such a small point. Let us finish.
If Lordship come to page 31, Lordship. Page 31. This is the debit note, Lordship. Debit note was dated 25/4/2023 and same was issued for a period from 1/3/2011 to 28/2/2013. For the retrospective period, not for the prospective period, Lordship.
By submitting the objection.
If
Submitting
this
the
debit-
30 days, the respondent shall consider the same taking into account the offending fact. Till then, the debit note shall remain suspended so far as the petitioners are concerned. Then,
If Lordship come to this debit notes against that e-auction scheme, Lordship, if Lordship come to page 25, Lordship. 25, page 25, 6.4 clause. 6.5. Before allotted, Lordship,
so are you saying that in view of that order, you are not liable?
yes, Lordship.
That case.
So if Lordship come to,
No, no,
Lordship,
you don't
come
have
to
a
page
case.
25, Lordship, 6.5, Lordship.
No case.
Before allotted, Lordship, the buyer have to pay the
Let's see
100%, Lordship.
what Calcutta High Court judgment is see.
Lordship.
Let's finish it off these 15 matters. Unnecessary. Then you directly go from here to the Supreme Court. What do you say, Mr. Kant?
At present,
It's
that was-
already there. Cannot be on the basis of an order. The contract is already there. They were supposed to submit a representation. And on the basis of the representation, you, at best, the debit note shall not be done. What do you mean?
Already we have
Now,
submitted
tomorrow, if you
presentation.
don't do it, let us assume that order, whatever it is to that order, it is subject matter of the representation. Now, but that is the power to acquire is on the basis of the contract. The contract is very clear that this will be additional payment which is to be made.
Yes, Lordship, we are agreed to pay for the prospective period, not for the retrospective period, for the sale which. If Lordship come to page 25, Lordship, there is specific Lordship, specific clauses there. Page 26.5, I mean, a lot of.
No. You, I'm asking you. If it is a case where you have, these clauses were not there in the e-auction. And then now in a recent time, they have incorporated. Now they are demanding for those periods, then it is illegal. But if at the time when the e-auction was there, this clause was there.
Not there, Lordship, not there.
Huh?
Lordship,
Why you are including
Lordship,
this
this-
document?
Here.
Show me the another document, this is of 2007.
2007.
This is terms and conditions of spot auction of 2007.
Seven,
Then this happened in 2011 to 13. Then it is very clear, it is not there.
Lordship, if Lordship come to page 25, 6.5, Lordship, it will be clear, Lordship.
25,
25 plus 6.5.
6.5.
I'm be allowed to read. However, a successful bidder whose allotted quantity is only 50 tons will be allowed to deposit coal value for minimum 90%, that is 45 tons within the stipulated period of 7 days, without which the amount shall not be accepted. Within 7 days, we have to pay the 100%, Lordship.
How is this relevant?
In such event, they shall be permitted to deposit the balance fractional amount limited to 10% to the or 10% of the total coal value of 50 tons within a subsequent period of 3 working days. In spite of this, if they fail to deposit the coal value of 50 tons, the EMD of entire 50 tons will be forfeited.
How does it have any relevance as regards royalty and all?
The coal value is there. The coal value.
Mr. Counsel, I have dealt with these aspects very deeply on that other matter. No? If I give it in your favor, if you see me.
That all are different, Lordship.
No, I
That
know
I-
that,
EMD were
but I have
for
dealt with this auction.
EMD were
The
for the
auction.
Lordship.
That is for the payment which is to be
Lordship,
made.
today I have
I
clear
am-
Lordship, Kali.
Another case.
The matter.
2013 doesn't look nice.
Let me know any other day, Lordship.
Isn't it?
In the morning time also has sought for an adjournment.
Oh. We have it after vacation then.
Lordship.
I'm not going to stay because of the Supreme Court business, huh? No business out there. Unless you get a stay order from the Supreme Court, then look here, this course is nothing. The matter that was listed before the Honorable Court on so and so, all groups so and so. If the counsel will opinion will not stay at all. All the responding matters are a statement of the case has not been filed by any of the parties. Relevant. Therefore, retrospective value addition to the code by adding these two elements for computation does not arise. Manager Pankaj who has filed approached the Supreme Court to seek transfer of the cases, but those petitions were rejected on demand by the Supreme Court, and the High Court is requested to extend the disposal of the pending return preferably. Petitioner failed to apprise this court about the order passed by the apex court, and these cases are listed for the first time long after the Supreme Court. But today the court finds that necessary are yet to be implemented by the petitioner as well as ordered by it. Therefore, DB Gogoi Learned Counsel for AI improvement. In view of the actions are not in the cases are not ready, and therefore the petitioner are directed to take increased steps for improvement. So, transfer petitions were filed, all were rejected. Then, that is why you are not filing, isn't it? It is recorded in the order of 5/6/2016. What does he say? But necessary steps for implement is not taken. Few parties, including Pompous Coal Enterprise, who have filed WPC number 6150, is it there? Approached the Supreme Court to seek transfer of the cases, but these petitions were rejected on so and so by the Supreme Court, and the High Court is requested to expedite the disposal. And now you are asking me all these things.
Item 16.
Yet to be heard in dispute. There is no dispute of the fact that we can. Nothing doing. We finish it up by tomorrow.
Just after which sounds.
Tomorrow. Supreme Court direction is to do it in 4 months. So I will consider it 4 days from the date I've started hearing. We'll get the order by tomorrow. Not tomorrow, okay. We'll have it on 17, no time. 19, yes. 19, we get your orders ready by 1 o'clock?
19.
Matters having been heard at length, leave these matters again on.
26 September.
Leave these matters again on 22nd of October 2024 at the top of the list. We'll be finished, no more. This will come before me on that day on 26th October. And by 1 o'clock we will get the order. In spite of the order passed by Justice Rishikesh Roy making it clear to be disposed of, you have the audacity to submit before this court that matter is pending before the Supreme Court. And all this while these matters have been adjourned on that ground, wherein the Supreme Court said, directed the High Court to dispose of all these matters. Goodness.
Item 23.
Actually, allowed to withdraw this petition, Lordship. My lord, in this matter, I am for the 5 statement number 6. I am told by the party that some agreement is going to be executed in writing, to be part of the record will made and will be placed before the court. That was instructed.
He wants to withdraw. Are you also a
Applications.
co-petitioner?
My lord, I instructed so.
Are you a co-petitioner?
No, that's what my instruction is.
Your name?
Is that authority?
So appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant writ petition. And submits that he has instructions from the client to withdraw the instant writ petition. Taking into account the above, the instant writ petition stands closed on withdrawal. Interim orders, if any, stands vacated.
Apply.
24.
Yes, what is this?
My lord, here in this case, my lord, the petitioner's lands were acquired by the DRDO, but without any compensation, without following due process of law. And over the land of the petitioner, the DRDO established their project, but no payment has been made. Deputy Commissioner also submitted a detailed affidavit, my lord, to that effect.
That it is your land
Yes,
and there is no compensation,
no compensation,
no acquisition.
no acquisition.
Okay. Let the DRDO get out.
My lord, can we see the affidavit filed by the
Huh?
I may pay for the DRDO. We have
Vacate,
paid,
vacate it.
Lordship, we have paid the entire amount to the deputy commissioner. Lord.
But where is the acquisition?
If it is there,
Show me.
okay, page 9 of my affidavit.
Page.
9.
Oh. Page 9. Filed by
Filed by the respondent number 1,
respondent number 1.
Venkateswar.
Affidavit. Hemango Das.
Yes, sir.
Huh?
Yes.
Okay, parawise woman makes an amount of year towards compensation, exploration, and net so and so of an amount towards wildlife protection have been deposited in Iman. Reserve forest and the same was intimated to Iman. However, during physical possession over the land, it is found that some people claiming as Patadals are residing in the reserve forest and some land were under some villages. The total extent of this land related in Iman. And in view of the office of the Victoria, the Austria conduct requiring and to the DRDO. As per the above mentioned, the regulation of the entire. Avoid delaying the ground, they disputed that. Speaking plan to the forest department to be first. The compensatory approach that whether to get
So, 15 to 5, 24, 5.
where is the acquisition?
But can we see one affidavit filed by the Deputy Commissioner on 24/5/2024? there is everything, it has been cleared. 24/5/2024. Page 50, from page 55.
There are certain acquisition proceedings. 24/5, yes, then,
Page 60, kindly.
huh?
Page 60. Internal page 6.
6.
Later on, it has come to the notice of the deponent that the instruction dated so and so, which was placed before the honorable court, was not related to the land in question of the instant writ petition. Due to inadvertent instruction dated so and so was wrongly placed by mentioning the village so and so of so and so under North Guwahati Revenue Circle, which ought to have been village Notun Nasab so and so under Kamalpur Revenue Circle. Hence, the deponent apologizes for the same and crave leave of this honorable court to submit a correct instruction dated so and so. The correct instruction dated so and so inter alia states that tag number so and so belongs to the village Notun Nasab of so and so under Kamalpur Revenue Circle is currently seen to be under the possession of DRDO as reported by the Land Record Authority. However, the names of the writ petitioners, Madhuram Das and 15 others, as mentioned in case number so and so, are found to be recorded Patadar against tag number so and so belong to the village of Notun Nasab. Accordingly, Chitha copies are also enclosed. And in the acquisition proceeding, these land were not there.
You are owner of
this tag number 29, 30, 31, 32, 33.
patta number?
Patta number I have mentioned, I am giving. It is in the writ petition. Patta number 71, which relates to.
So your lands are there.
Yes.
And what is this forest doing? These are reserve forest. Huh?
Forest. Reserve forest.
Then how pattas have been issued?
Initially, they are taken stand that the reserve, when it was reserved, then our land was acquired. But that also they have failed to produce any document that our land was acquired. Because under the forest regulation also, there is a provision of section 11 regarding how the land is to be acquired. There is no such acquisition with respect to our land.
For reservation, it will be done under 35 of the Wildlife Protection Act.
Okay, it's power under 11 also. Under
No.
forest
See,
regulation.
for Wildlife Protection Act, they can reserve it and they
They can
will
reserve.
make the acquisition in terms with that. For
Yes.
that, there will be, it will be
Acquisition.
parameteria in terms with the Land Acquisition Act 1894.
In the forest regulation also, there is a provision, same.
No, this is the different. Forest regulation is from 6 onwards.
Yes.
From 6 onwards, how it
There's
is to be
similar
done.
provision for
Yeah.
agri.
But the Wildlife Protection Act,
Is,
72 also
yes,
gives,
72 also.
that said at paragraph.
Not has been done. Our land is the Patta land were there. DRDO was established. DRDO has thinking that this land were forest land given to the DRDO.
And there is no, there were certain acquisition proceedings with
With
these are-
respect to other land, not
Not
with
yours.
respect to my land. Other land, there is a proceeding.
Hello, Diedo, Wicket,
My lordship, power equity been kindly missing.
your affidavit, I've seen it,
Page 4, paragraph 4.
seen it. Your affidavit does not say anything. Your affidavit does not say that that land has been acquired. You stop at,
Land has been acquired by the petty commissioner.
where's the acquisition? Show me. Where have you mentioned that the land has been acquired? You only say section 4 notification.
may read paragraph 4. Paragraph 4. Affidavit
I
further
read from paragraph 4.
that before giving further reply to the agreements made in the writ petition, the respondent begs to state that an amount of rupees 33 crores and all. Made
You see, you have paid some money to somebody.
to the,
That does not mean that you are going to take petitioner's possession.
no, Lordship, the forest land under Nathuicha Reserve Forest, based on demand, they will take an order officer,
How can, if it is a reserve forest, there can be a patta granted?
seedling, Lordship, then subpara,
And if it is a reserve forest, they have to de-reserve.
yes, Lordship, that is our contention, Lordship.
Have
However,
you de-reserved it?
Lordship,
When?
no, we have not reserved. It is.
The forest, you have de-reserved it. Huh?
That instruction is that this is of the law.
It can't be de-reserved unless it is done before 84.
Lordship, subpara. However, during a physical position over the land, it has been found some people claiming that Patadar are residing inside the reserve forest, and some land was under position of some of the villagers were claiming as Patadar. The total extent to this dispute, land is 190 biga, 1 katta, 2 lechas. And in view of this, the Deputy Commissioner Kamrup Rural.
Mr. Kayal, this is a case where you have paid the money to the acquiring authority. The acquiring authority has not done anything. They have not gone for acquisition of the petitioner's land. Petitioners have patta lands.
Let's see their prayers in the writ petition.
We modify it. That's not what you mean.
That in the nature of the note, we should direct the respondent to pay the adequate compensation.
Huh?
The petitioner for acquisition of
What is the prayer made?
page 8 of the writ petition.
Pay adequate compensation.
Pay
For
the
acquisition of
adequate
patta land way back. But where is the land acquired? Has it been acquired? No. There is no acquisition. Your case finishes prior to 2008. Your affidavit.
Okay, then, last paragraph of, paragraph. As per the above minutes, there was a meeting held between the Deputy Commissioner and the official of the DRDO. Then it was decided that Deputy Commissioner Kamru, Amingaon has advised DRDO to leave 115 bigha of land out of 1904 is outside the core area of DRDO to avoid delay in implementation of the project due to the ongoing dispute regarding the land, and also suggested that DRDO to defend the.
See, the deputy commissioner, who is the revenue authority, categorically says that the land of the petitioner have not been acquired.
Lordship, we have revert back 115 bigha to the Deputy Commissioner.
You revert how much, I'm not concerned, but are you in possession of petitioner's land, which is as per the deputy commissioner's affidavit? Yes. The fact that the petitioners have patta over the land is also yes.
Then I'll produce all the documents, Lordship, how much land is under the position of DRDO, and produce the details.
Other affidavit also shows that in the core area, our land falls. That is why it is not possible to pack it. It is within the core area of the DRDO, our land falls. And they want to leave the land which is not within the core area. We are not concerned with other lands. We are not concerned with other lands. We are concerned with only with respect to our land.
How long the DRDO has been there?
2008 project started.
And why have you filed the petition so late?
2019 deputy commissioner on repeatedly.
No, forget about the
There are-
deputy commissioner. Why have you filed the petition 11 years after?
My lord, we are.
Your basic prayer, Mr. Counsel, your basic prayer is that you want compensation.
Compensation, yes.
Why you are coming up with all this
No,
thing?
I am-
You want that area only.
No, I. do
Don't
not
come
know.
up with this.
Our only compensation, my lord.
Absolutely
adequate
no.
compensation.
This submission cannot be
No,
told.
I am not saying, I am saying that why it is
So
not.
we are not,
possible.
if you want, you may be given outside the land also, whatever may be. But the fact that it is in the core area, it's a question of compensation,
Yes.
then look into that.
That is.
But don't come
my
up
prayer.
with this thing. that we don't want any other land, only
No, no,
that land which is there.
Our compensation, we are only with respect to compensation.
Mr. Hendrik, from the affidavit filed by the respondent, means deceased, it appears that the land of the petitioners have not been acquired, as could be seen from the affidavit. We have this matter on the month of November. You just find out, both of you, along with the deceased, communicate as to whether the petitioner's land have been acquired in terms of the acquisition proceedings. If not, what further steps can be taken? Because if it is not been acquired, something has to be done.
Yes.
Petitioner is entitled to his
Yes,
compensation.
that is.
So this is what, because one has to come to a solution, saying about reserved land, well, we are not concerned to that effect. First of all, the forest department doesn't know head or tail about all these things. They are only in concern with other aspects of the matter. They're not bothered with many things. And this is nearby, na? So that is why they are more not concerned. Nearby.
Is in, Amingaon.
So Amingaon is, for them, one has to cross the river by swimming, so they can't get anything.
No, Lordship, sir.
Huh?
Lordship, what happened, DRDO?
No, their problem, not your problem, their problem. So they won't help you out. So the question now therefore arises is, both of you find out what is to be done. Is this matter on 13th of November, 14th of November 2024, on which date Mr. S.C. Kyle and the DRDO as well as the district administration shall, upon making necessary verification, apprise this court as to whether any land of the petitioners which in land of the petitioner as stated in the petition have been acquired by the district administration, and if not, what steps are going to be taken, the authorities, the state authorities propose should be taken in order to redress the grievance of the petition.
Item 26.
Yes, Mr. B. Sharma. New matter.
Old matter, it's old matter. The matter pertains to levy of demurrage charged by the railways from the petitioner, my lord. Here, my lord, before my learned friend starts making a submission, my lord, I just want to point out two things, my lord. I've taken the objection of maintainability of the writ petition on the count that since the petitioner is a company, my lord, there has to be a resolution by the board of directors, my lord, coming to a decision that they are going to approach this honorable court, and someone has to be given the authority to file this writ petition or swear the affidavit. In spite of specifically taking that plea, my lord, they have replied in their affidavit in reply that it's not required. Now, whether this writ petition would be maintainable under such circumstances. And secondly, my lord, between the same parties, a similar matter has already been decided by this honorable court, and it has been held that since there is a provision for second appeal before the authorities, they will have to approach that authority first, then they may approach. Because
That is the order passed by Justice Manish Chaudhary.
yes. Because,
That is the order.
yes. It's an administrative
That is half the order. I don't have the full order.
from paragraph, I can hand over another copy.
What are these matters about?
Levy of panel demurrage charge. Because they could not clear the rolling stock, my lord, within the free time that was allotted to them.
How much you are claiming? 4 times?
6 times.
It's graded, my lord. For the first 2 hours, it's 2 times. For the next 2 hours, it's 4 times in that manner. It's graded.
Petitioner have deposited the amount.
In this case, no, in that case, same petitioner, in that case, they have
But this is a different subject matter.
same subject.
Huh?
Same, yes, yes.
Lordship, my point of argument is different, Lordship. That judgment was delivered on different note, my lord. Different foot, my lord. My case is, my lord,
Different?
different foot, my lord. That judgment, the judge, Justice Manish Chaudhary has delivered this judgment, Lordship. In that case, Lordship, their second appeal was not entertained, my lord. They have not preferred second appeal. And Lordship, against that second appeal, they also did not file any delayed condemnation application, Lordship.
So there is
for
a
that
stay now? Stay?
There is the order.
Stay order is there?
So unnecessarily pending, my lord, let the authorities have their say in the matter, my lord. Thereafter, if the decision goes against them, they can definitely approach this honorable court again. But that distinction which is vested in the authorities, that has to be exercised.
They are challenging what?
we are challenging the DC bill, which is at page.
Have they paid their bill?
No, Lordship.
Oh,
My case is, Lordship, their levy of panel damage charge is not applicable because, Lordship, the mandatory two procedures, they have not complied, Lordship, in terms of the rate master circular dated 19/5/2016. In that circular, Lordship.
okay, we'll have it some other day after vacation. Okay? Hello. List the matter again on, when do you want it?
Vacation. Let it be on, Lordship, 25th.
What?
25th, sorry,
Next month, will I do?
24th of October, it's hearing day, Lordship.
24th of October, it's a Thursday.
Thursday.
5th of November, list the matter again on 5th of November 2020. Let the weather become more cooler. Let's-
Obliged.